Whenever.
Good morning, everybody. We want to welcome you to the October the 20th, 2016 meeting of the Alarm Systems Contractors Board. We want to welcome all the visitors and guests that we have here today. And Ms. Vest, would you please call the roll?
Thank you. Scott Cockcroft.
Here.
Keith Harvey.
Here.
Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts.
Here.
You have a quorum, Madam Chair.
Okay, thank you. The first item on our agenda is to review and adopt the agenda for today's meeting, and if so, do we have a motion to adopt?
Chair, would you like to repeat that again, please?
First item on our agenda today is the agenda for today's meeting. If the members will review and a motion to adopt.
Madam Chairman, I make a motion we adopt the agenda as it's presented.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to adopt today's meeting agenda. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next item are the minutes from the August the 18th, 2016 board meeting. If the members have had an opportunity to review those, and if so, a motion to approve.
I make a motion to approve the minutes as presented.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Ms. Jones to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The minutes are approved. Next on our agenda is the presentation from the Director of Program and Policy, Rachel Powers.
Just a slight change to that.
Okay.
I'll go ahead and start with this presentation. As the board is aware, in May of this year, new rules went into effect for the registered employees that applied expiration dates to their registration cards. Once that rule went into effect and those expiration dates were added to the registered employees' cards, companies began to attempt to comply. And their efforts of compliance led to an influx of what could be seen as violations because we did not receive termination notices timely and or registration applications timely. You'll see that reflected in today's legal report. It's our goal to come up with a way to get that compliance without being so burdensome on the board staff. So what we would like to do is have the board consider entering into an agreed citation schedule, and that would be something that the board office could administratively handle and send that out rather than and leave the complaints that really affect the public to the board to consider. I know Mr. McCormick is here as well as Mr. Driver if they had anything to add at this time. But that's something I would like for you all to consider. We do have a copy of your fee schedule that we'll be looking at to see if those particular activities would comply with that and maybe the different amounts, and maybe present that to you at the December board meeting.
Okay. Mr. McCormick?
Everybody, thank you. And I'll just basically kind of follow up with what Ashley said here in terms of, I think we're talking very specifically about, I'm going to focus very specifically on what the area she just talked about. And I think for us, what happened was you all had, we were looking at this from a complaint-based process, and so we ended up having, I believe, something like 77 complaints opened in the first month related to this issue. And so last year you all had 73 total complaints for the entire year, and this was 1 month. So obviously the impact is going to be pretty burdensome, and really what we're seeing already is entities complying fairly quickly. So we've talked about a process, I think, that will be fairly I think more efficient for you all to make sure you get compliance, and will provide an opportunity through the agreed citation process. I think initially we have a way that we can send them a letter of warning to say get in compliance, and then at that point on the second indication of that, we would go to the agreed citation process, which would allow for I think another quick way for compliance, which ultimately is what we're trying to do here. And I think you're going to see pretty quick adoption here. But what we don't want to do is come to you with a legal report every month with 77 complaints that you're going to have to review. I mean, that's, like I said, that's obviously a significant impact to the board, and it potentially, if there's any additional pieces to it, could provide cost implications. So we're trying to do this in a way that really achieves your goal of getting compliance. And like I said, I think you're already on the path to do that anyways. I think the companies are seeing this and I mean, most of these have been self-reported. So.
They have all been self-reported. As I said, it came as a result of the expiration dates being added to registered employees' registration cards, and the companies began to report and comply. And as Brian said, it did create an influx of approximately 77 complaints. And rather than present those to you, like I said, we are looking at going into an agreed citation schedule, of course, with you guys' approval as to what violations would match that and what would be the appropriate discipline going forward for that.
Robert?
I think the only thing I would note is we've had some success with this sort of arrangement with some other boards and commissions. The idea is that it's a procedural change. What the board is doing is on these sorts on I guess approved categories of complaints, instead of those going through the current complaint standard operating procedure, which results in the matters being opened, sent to legal, and then investigated as appropriate and presented to you all on the legal report. You are delegating to Director Vest the authority to review those complaints, and if it appears appropriate in those cases, to say this falls within the schedule that has been approved by the board, and as such, I am authorized to either, depending on the schedule you all authorize, send a letter of warning if it's the first violation for this company, or send what we're calling an agreed citation, but it's pretty much a consent order. That's an offer to settle it on a second violation. Of course, the reason I say it's a procedural change is because if it's not closed, as a first violation, if a agreed citation is not or is sent out and it's not accepted, the complaint still goes through the regular process at that point. It would then be sent to legal if we can't reach a resolution. The idea is in complaints where we have a high volume of complaints that appear technical in nature, to speed those through the system and to give people a chance to show compliance earlier on. And I think it's been, although I don't have data on this, at least the colloquial or the kind of observational data that people also tend to comply if they're given a chance to do so faster, as opposed to maybe getting something 8 months down the road or whatever that is, 6 months down the road, that says, oh, you did this. And by then, many times they've forgotten about it or had thought it had been resolved with their complaint or something along those lines.
You already have a procedure in place that applies to other boards that we could tailor and adopt for ourselves? And are you going to present that in your legal report or on down?
As far as the agreed citation, we are going to look at, like I said, the fees and everything, and probably present that more formally to you in December. I wanted to bring it to your attention because a lot of the complaints that were open as a result of the rule effectiveness are reflected on this legal report. So I wanted to bring it to your attention that this is why there are so many cases on this legal report, and this is our process for going forward to try to eliminate some of that burdensome workload going forward to the program.
Well, let me ask you, when we get to Ashley's legal report today, if there are some in bulk that are all the same, would we have to look at those individually, or all of the ones that fit the same category? Could we just vote in?
And that's the way that I presented
those?
it to you all.
Okay, good.
The same issue will be presented in bulk. Like I said, you'll see it reflected in the first couple of cases listed on the legal report.
Okay, thank you.
But going forward, something like that would not come to the board if you all approved it. Cody's office would handle that going forward with the agreed citation that you all have set forth.
My concern is that if we have a rule that has created a tremendous number of technical violations, should we be looking at the rule rather than how to just administratively deal with the violation? It sounds like there's that perhaps the rule is the underlying problem rather than just perhaps putting some sort of a Band-Aid on it. And have we created a burden on the industry with this rule?
What I will say is my understanding is, and it may be Director Vester or Ashley may be able to correct me here if I'm not mistaken, is that what is being found was already a violation of the rule, which was the failure to timely report the termination of an employee. What has happened is because of administrative changes, we are receiving better reporting of those things. And so what we're now finding out is there are a large number of these that probably in the past were not coming to the board's attention that are now coming to the board's attention. And so what you have, I think, is not necessarily an influx of additional violations. What we have now is better reporting of those violations and finding a much higher number of those. Now, of course, at the end of the day, if the board wants to change those things, that's entirely up to you. But that's my understanding of the nature of it, is that these already would have been violations. The information that these violations were occurring just wasn't being reported to the board at the same rate that it is now.
I think our concern might be that that possibly we need to look at the rule itself, because maybe it's burdensome. I imagine most of these are coming up at this point from honest mistakes.
Right.
People didn't know that they had the employee registered. They're getting the renewals and finding out. So then they're being honest, and if they're getting a violation, they're putting an honest termination date. May have been 5 years ago or 10 years ago or
But isn't
1 year
this
ago.
something that will work itself out in time?
That's actually what I was going to chime in and say. I think really this is going to sort of solve itself. I think you're looking at something that's much more temporary. In fact, kind of my suggestion today, and I'd actually was hoping that the board would, I would suggest the board make a preliminary decision to. My view on this is, and it sounds like I hear you all saying, look, we're not necessarily wanting to hold a bunch of people accountable for technical violations, and these companies are actually saying, hey, we're trying to comply. My suggestion would be, since it is an issue that you do want to regulate, and I think there are some potential reasons here for protecting the public why you may want to have this compliance occur. What you could say is, anytime we're notified of someone who has not effectively reported, the first time that they do that, you just go ahead and say, administratively, the office can go ahead and send them a letter of warning saying, thank you for compliance, please don't do this in the future. If you fail to comply in the future, there could potentially be subsequent discipline. And I think that will then allow you to have the agreed citation process on the back end, which will only deal with the people that we know are really not complying. But I really think, as Ms. Hickson
Like
said,
a housekeeping
I
matter,
agree. I
once you
think-
get everybody
I think
on
you'll
the
get-
same
Could we
wavelength.
do some sort of an amnesty period that we wouldn't, or is like that word possibly, or?
It's going to hit a 2-year cycle.
Okay. Want to explain it to me?
The renewals are on a 2-year cycle, so it's going to continue until we finish that cycle.
I just don't see how it jeopardizes the public in any way. Really, if we don't get the card back, there's not anything. If the employee did something while he was there, it would get reported that he was arrested or whatever violation happened. But I just don't see how the public is endangered by someone not reporting an employee.
And it's for
terminated.
that reason that we suggested this going to an agreed citation issue, because like you said, it is housekeeping, it's an administrative thing.
I agree with that. I think it might be a bigger issue, though, that maybe the 30 days is too short of a period, or I don't see how the public is in any way endangered. I know of a company that had his son work for him, and he forgot to turn in the termination on his son because he wasn't working for him anymore. But he would have him work on a job 10 years later. I mean, it's his son. He would like to have kept him registered. But that was one of those things that was a housekeeping issue. He didn't turn it in. He did finally terminate him. Well, he's now hired his son back. So I don't see how the public was ever endangered by not terminating an employee.
I think I would say that there is some value, because this information is uploaded on our Verify system for the public to look to see who's. I think those are the components of it which are valuable, and I think you all have said is valuable. But I very much empathize with the idea that this is not something that we think we want to be coming down heavy-handed on folks
Right.
for. I think that's really why I was kind of inserting here to say, I know we've talked about an agreed citation process. I think that is fine, and you can further that as a potential option, I think, down the road. But right now, if you go ahead and say any first-time violators that are self-reporting, we can just direct to say, thank you for compliance. We've sent a letter of warning. What you're doing is you're meeting your requirement to say, this is something that's important. It is a violation, and we're notifying you of that, but thank you for your compliance. And we very well can craft a letter that would be reflective, that is not intended to be heavy-handed or really just kind of getting to the point. Thank you for complying. I mean, there are ways that we can really work to kind of achieve, I think, both of the goals.
We've used letter of warnings a lot in the past when it was just a simple oversight or something that happened years in the past that's caused a change, that it's not necessarily to fine anybody, but just to bring them into compliance with the rules.
I think you could go ahead and say, based on the fact that this is a pretty simple violation, and that would be my suggestion, is a simple violation. It doesn't even come to you. That you can empower Cody and her team to go ahead, and when that comes in, they know what number kind of resolves the issue, so they don't, we don't have this continued and I believe if we do have people who are continuing to not comply, then maybe we know at that point, if this is something that you all think is problematic, that you think is needed, at that point, I think that's probably a good time to say, well, what's going on? Why do we have rampant failure to report at this point? I think the industry seems, based on what we've seen so far, it seems like everybody is trying to comply. So I really think this is going to be a short-term issue.
A significant number of our first violations are a letter of warning anyway, and so that would be in keeping with this, perhaps. That would make sense to me.
And it's also something that the TINS organization could send out to the
Tennessee Electronic Security Association.
They could send out, through the organization, to just remind people about the expiration date too.
Well, the problem is before they had one expiration date, and that was with the company license, and now they're going to have 12 expiration dates, one each month. So that complicates things. But still,
they will be getting notices going forward, though. At least where in the past they had no notice of renewal, or there was nothing to flag them that employee was still registered.
The idea of administratively giving those that class of violation a letter of warning would make a lot of sense to me, and put the companies on notice that they need to watch it a little closer in the future. And again, that would not add an undue burden onto the staff or legal or the board, or I don't think, given the circumstances, it would create a burden on anybody and be fair to all concerned. But I think if it does continue to be an ongoing problem, that we might need to take a good hard look at the rule that's involved with that down the road.
And while you all, I mean, obviously can look at the rule, I do want to point out, I think the assistant commissioner's pointed this out too. I think the idea, while I understand the issue with the family member, the idea is that if someone's going into someone's home and these people are in a position of trust and they still have that card, and they call us and they haven't been terminated, and they say, oh, is this person authorized to come into my house? And we look and we say, yes. I think that's the big concern with not receiving these notifications. And while I do think you're right, a lot of these are probably those sorts of unwitting violations. I think that's the concern, is that if someone called us and we didn't know that they had been terminated by that company, because the only way we know is if we're told that that information could get passed on to a consumer, and potentially someone who isn't there on authentic business could then be allowed access to a citizen of the state of Tennessee's home. And I think that's the principal concern, and the reasoning for this, just to keep that in mind, I think, in the broader picture.
Also, the new IDs will expire, right? The current ones don't. I mean, the card doesn't have an expiration date. So that'll help that issue to some extent. I think we're on the same page.
Yeah.
I think we.
Yeah. Okay. Any other thing?
I guess if you all wanted to consider, and again, to authorize Director Vest to send a letter of warning to a person that appears to be self-reporting a first violation of a failure to terminate, that would take a motion, and second, the approval of the board, if that's something you all want to consider today.
Would that be okay with you, Ashley, or would you rather us wait till December and you bring it back to the board then?
This is fine, to go ahead and do that today. And if I find that there are additional things that seem to rise to that same level, I can present that in December. But as of right now, to address what is currently happening, I think it's best if we go ahead and make a motion today, if you all are prepared to do that.
Trying to think how to word that would cover the appropriate circumstances. Let me propose, Madam Chairman, a motion whereby staff and legal could administratively issue a letter of warning to companies that have self-reported or they're self-reporting a technical violation of failure to report a termination of a registered employee in a timely fashion. Let me put a limit on that for, say, 6 months, and then let's come back and look at that. Would that seem appropriate? Because, like I say, I'm concerned if we've got if we've created a problem with the rules, and I'd like to have that brought back to us so we could reconsider that. But if we did that for, say, 6 months, and that's kind of an arbitrary time frame, then that would and we could extend that if that seems appropriate. Let's give it a try and see how it works.
Which we probably would need to extend it because you're saying a 2-year renewal cycle. It will be ongoing for 2 years. Could be.
Let's do it for 6 months at this point, and 6 months from now, take a look at it, and or perhaps sooner than that, and where we could re-examine it.
Whatever you would like to do be fine, but I will be coming back to you with the rules. We do, yes, I do agree that we will need to address those.
Okay. So that would be, is that a reasonably clear motion?
I think it is, Ashley. Mr. McCormick?
I was just gonna make sure if for when you put a timeline, this as you put the timeline on it, maybe make sure that it's done in a way that it's not in between board meetings. That was one of my thoughts. That way we I think if you say you want us to, if we could keep it in place, but we'll bring it back to you in 6 months or close as, I just didn't want to get in a spot where it was, a month before a board meeting. That way we
meet every other month,
right,
so that would be reasonable, but
just as a, I know they're going to be coming back to talk about some of this subject a little bit more in depth next month anyway. So the conversation we would hope would be ongoing anyways.
Well, this motion would provide a Band-Aid until we could get the fine details worked out and then vote again in December if we need to modify it.
We are scheduled to meet on April the 20th of
So that would be 6
2017.
months.
That would be 6 months.
okay.
We could vote to extend it though in December, or could we
Oh,
not?
yes, you
Yes.
can
We
at any time, yes.
All right, we have a motion by Mr. Roberts to allow the staff and legal to issue letters of warning to companies who self-report technical violations for failure to notify the termination of employees in a timely manner of 6 months. Correct?
Registered employees.
Add registered employees into that, please, instead of just employees. Do we have a second to this motion?
Second.
And a second by Mr. Cockcroft.
Let me ask now.
Okay.
Now that we've got a motion and a
Okay.
second, is the bulk of the problem seem to be a failure to report termination of employees? That's what you had indicated, but is that going to cover us, or are there other issues that are falling in the same category?
The only other thing that's probably comparable to it at this time is the registering of the employee applications timely within 30 days. It appears to be the same issue of failing to submit them. I don't know if when they start the companies but we've received an influx of those complaints as well. That we've seen an uptick of those as well.
And would it be all right to go ahead and vote on this motion and then propose a second motion to address the timely registration of the employees?
I think it'd be the thing to
Yeah.
do, because timely registration of employees is something we've had all along.
Correct.
And I think we probably need to leave that like it is. So my recommendation would be that we go ahead and vote on the motion we have on the floor.
In this motion, yes. Okay. Keith, Karen, y'all understand what, okay. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Now, we need a motion addressing the timely registration, or timely submission of registration for registry employees.
Madam Chair, what that is simply is on the application we asked you when you were employed with the company. What we are seeing, and we have a flux of complaints, is that they are putting the date that the employee was hired with the company, not the date that they're coming into Tennessee. That has always been a problem, and it has actually become very burdensome.
I agree with Ken from the standpoint of the new employees, but I think on this issue, the issue you're talking about, where you can verify, where we can handle something administratively, where if it is that they were employed in Kentucky for 5 years and then moved to Tennessee, I would think that would be something that could be handled administratively. Would you agree with that?
Yeah, I really would. It would seem to me that maybe changing the wording on the application might address that issue as much as anything.
We have, and then we do have a change on that, and then we are putting on in Tennessee, but they still, my office is having to make phone calls to the company so they don't turn them into complaints. So it's burdensome on that, and what you're going to hear today is the flux of those applications.
I'm reluctant to extend the time that
I don't want to extend the time.
a
I just want
company
a
is
motion.
required to register their employees. I really don't think we need to be extending
Well, I don't
that.
think that's what we're addressing. We're addressing letting the staff and legal handle it with the same as what we're doing on the termination, only to address them not submitting the applications within 30 days, so that we don't have to vote on it as a board, that they haven't gotten their application in within the 30 days. Let them.
Are they both 30 days? Or is one 90 days? They're both 30 days?
30 days.
Okay. Ken, I think I agree with you from the standpoint of if they truly were employed in Tennessee prior to the 30 days, I think that shouldn't be handled administratively. But I don't think that's not the issue that you're seeing. If we're
That's correct. You're correct.
would you not be okay with if it was a clerical error where they reported the wrong date? They reported a date where they really weren't working in Tennessee?
Well, if there's a clerical error of that type, yeah, I would think handling that administratively would make a lot of sense.
We're trying to address.
I'm sorry, I didn't understand then. I thought we were talking in terms of a number of people that maybe a company here in Tennessee that's hiring employees. Okay, I would agree then with what you're suggesting. We want to put that in the form of a motion. I guess we need to. Again, Madam Chairman, I guess I would make a motion. Oh, don't ask me to write that down. I can't.
No, I've got it. If you can.
Well, I was going to say I can't
write it.
write.
I've written it down. So.
Write and talk at the same time is just beyond my education level, I fear. To allow legal staff and administrative to. Are you going to write it so I can read it?
To handle.
Wrong reporting dates when, wrong dates of employment when they've transferred, if you want, however you want to do it.
That transfers this application.
I'm sorry.
These are
Identical to the
applications where the employee has improperly reported his date of hire with the company.
Yeah.
Okay, so we have a motion then that would let the legal and staff administratively handle, and you wouldn't even need a letter of warning on that, would you? To let them administratively handle situations where an employee has improperly reported his date of hire with the company, or
Be his start date within Tennessee.
start date within Tennessee. Thank you. That's the best way to state
Did you
it.
get all of that?
That's the reason she's better at this than we are.
That's correct.
I figured after this many you'd be better.
Boom. Yeah.
It's only fine wines that improve with age.
Okay, we have a motion by Mr. Roberts to allow legal and staff to administratively handle incorrect hire dates with the company versus being registered in Tennessee. Do we have a second?
Second.
by Mr. Harvey. All in favor, voice by saying aye. Aye. All opposed? The motion carries. I'm sorry. I was going to...
Thank you all for having
Thank
us
you.
today.
Thank you, thank you.
It's always a pleasure.
Thank you for
I hope
coming.
we've given you something to have humor for the rest of the day. So was this the thing that the Rachel Powers listed? Okay. So the next thing is our legal report by Ms. Thomas.
Oh, you can say that.
Now we can skip it if you want to delay the pain.
No, we don't want to skip it, but I do want to go out of order just a little bit. If we can go to the case for represent, it's at the end of the legal report. The litigator that is handling the case now, Sarah Page, Sarapage, is going to present that case to you all, and then I'm going to let her get back to her day, and then we can.
Which one is it, Ashley?
It's on the last page of the legal report. It's number 1 under cases for represent.
It starts on page 7.
Number 13 on the legal report.
Technically, it should say number 1. So
That's it, right there.
2015.
The one right
018.
underneath number 13. Okay. Is everybody there?
Good morning, members of the board. Thank you so much for allowing me to appear before you. As Ashley said, my name is Sarah Page, and I'm currently a litigator with the department. This case was assigned to me to continue on to a hearing before this board. This case, complaint number 2015-08482, was opened as a result of the respondent engaging in a joint venture with another company in Tennessee. And as a result of that, respondent assisted in the sale of 5 alarm systems in 2015 without being licensed. The investigation indicated that the respondent no longer maintained a place of business in the state of Tennessee, and it was concluded because respondent failed to make, this was concluded because they stopped paying rent on their location and ultimately couldn't find any indication that they were paid. Since I received the case in an attempt to continue the process forward, the legal department has been unable to contact anybody associated with the respondent. Efforts that we've taken are running clear reports, which are fairly extensive background checks on all of the known members of the organization. We've emailed employees on any number that we can find. We've called every number that is in the background report. They've all listed as disconnected. All of the emails have bounced back to us indicating that they're no longer active. They had an accountant file their dissolve their corporations in both the state of Kansas and state of Tennessee. I contacted that accountant and she informed me she had not heard or had any contact information from them since the beginning of 2015. We've also reached out to the state of Kansas and to their Secretary of State's office since they were previously listed as a corporation there, and they also did not have a good address and have been receiving their mail returned to them as well. The only other thing I could think of possibly was to try to have someone personally try to locate them in Kansas, but we don't have the authority to send any of our people, obviously, to Kansas. So I am asking that this board close this case on an inability to prosecute. The upside, I think, is that the other members of this joint venture did pay a $1,000 civil penalty and signed a consent order. So someone did ultimately receive discipline as a result of this unlicensed activity. I'd also let the board know that we would be sure to flag this case in the system. So if we did see anybody from the company individually or the company itself reappear, that we could readdress this complaint at that time. But at this point, I'm always open to the board. If you have any other ideas on how to locate them, I'd be happy to take those on and try them. But at this point, all of our ideas are exhausted. So that is my motion to request that this be closed and flagged for future.
This company was the one doing installs for another company that was licensed.
Yes, they did some phone. They called 5 people, helped with the deal, and then ultimately did the install.
I think they did a lot of the selling of the alarm systems. This company did in connection.
Does your CLEAR report show if they've started a business in another state besides Kansas?
If they registered it to themselves personally, yes. At this point, the last corporate formation under any of the officers' names is the respondent, which is dissolved.
Have a motion on the matter?
Madam Chairman, I make a motion that we concur with the recommendation we've just received, that we close and flag this particular case for the reasons that have just been outlined.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this matter to close and flag. All in favor, voice by saying aye. Aye. All opposed? The motion carries. Thank you.
Thank you.
Mr. Cockcroft.
If you're ready, we can go back to the top of the legal report.
Okay.
Okay. Okay, so the first case on the legal report, the below complaints allege that the named respondents failed to submit termination notices within 30 days of the employee's termination date, all being in violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K. The allegations arose following the board office's receipt of termination notices for registered employees no longer employed by the alarm systems contractors. The complaints listed below were opened after the board drafted rules, which went into effect May 26, 2016, and the qualifying agent submitted the termination notices in order to bring the companies into compliance. If the board needs me to, I can read each complaint into the record. But my recommendation for all of them is to issue a letter of warning, as we've discussed earlier, regarding Tennessee Comprehensive Rule and Regulation 0090-01-.069K and close. As I said, the violations were discovered upon the effectiveness of the rules entered May 26, 2016.
Would all of these fall within the action that the board took just a few minutes ago?
Yes, sir.
I think that that action should cover this, and I wouldn't think we need another motion that you've got sufficient authorization to deal with those.
Absolutely. And by that same argument, then we can probably skip ahead to number 3, because number 2 addresses the second motion you made earlier. So we'll move on to case number 3.
Now, all of these that were within case number 2, as you have it numbered here, are instances where they just put the wrong date or had a date of hire with the company rather than.
Yeah,
Yes.
yeah, she's got it
Was there
in
just
her.
one company involved, or there was a whole bunch of companies?
Or
Or
multiple companies.
Yeah, she's got it in there, the effective date of employment in the state versus the date of employment with the company. So we covered that with the motion that we previously.
Is that indicative of a surprising number of multi-state companies bringing their employees into Tennessee for the first time?
Multi-state companies, yes. Like I said, I think it all comes from adding that expiration date to the registered employees' registration cards. And so then when renewal notices go out, we have X number of employees registered with your company, and then we get companies submitting termination notices to comply or registration applications saying these are the people that actually work for me. And that's where the complaints came from.
I think what Ken was asking is this a high number of people that are companies transferring registered employees
In
in
from
and
out of
out?
state for some reason.
Well, it's like they're in and out a lot.
This has become a serious problem in the department. And when I said we need to sit down and take a look at the rules, yes, I believe are having a flux of applications that you're going to see. These are out-of-state.
You have to speak into the microphone.
These are not Tennessee companies. They're usually out-of-state companies. And that's all. It's always been a problem, but I don't think we knew, because we would see them just a little piece here, a little bit. When you put them all together, then it becomes a problem. We got on the phone. We've called them. We sent them notices. And they're going, no, I'm sorry. And I don't think no matter what we put on the application, they're going to be able to read it. They just put the date, he was hired at my company on this date. And I put that on there because I didn't move him in there today, but 3 months from now I might move him into Tennessee, is what we're getting.
Mm-hmm.
Okay, so
That is a problem.
it's not indicative of just a large number of people from out of state.
I
These
think
sound like
we're-
just in cases, just in case we need to
And,
put
and
this.
that is true. That has happened as well.
But again, if these cases fall within the previous board action, then I think we're clear on that. I was, I guess, surprised by the apparent large number of situations here.
These all fall within.
And that surprise ran from all the way up the chain. When the applications came in, the board staff was surprised. When they were referred to legal was surprised. When we presented to you, so everybody was surprised at that.
But these all fall within that 6-month rule that we
They
put
do.
in the first motion. Okay. I think we're good to go. You ready for number 3?
Yes, ma'am. Case number 3 is 2016-050-311. This complaint opened alleging that respondent failed to register an alarm employee within 30 days of the hire date in violation of Tennessee Code annotated 6232-312.
You're going too fast.
312.
She's going to slow down a little bit.
I thought I was. The board office received an application for registration on November 4th, 2015, which listed a hire date of June 29th, 2015. Respondent states the application and required fee was submitted on July 22nd, 2015. Respondent states that when the check did not clear the bank account, the board office was contacted. The board office informed respondent that the application was not received, and as a result, the application was resubmitted with a new fee payment on November 2nd, 2015. Documentary evidence submitted with the response corroborates respondent's statement. The failure of the application to be submitted within 30 days appears to have been an error out of the control of both the board office and the respondent, and my recommendation is to close. I presented this one separately because it's a bit of a different set of facts than the other cases.
Madam Chairman, I make a motion we concur with the recommendation of council and close this particular complaint.
Second.
We have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 4 is 2016-031-801. This complaint opened alleging that respondent is installing cameras and security equipment without a license. The complaint included a copy of a security system quote that included camera installation. Respondent states that the company does not install security systems, but rather the security work is contracted to a licensed alarm systems contractor. A statement was included from the alarm systems contractor, who indicated that the respondent incorporates a security systems estimate in the bids provided to customers. Respondent's witness indicates that the licensed company provides the installation, programming, and monitoring. My recommendation is to issue a letter of warning regarding Tennessee Code annotated 6232-304E and close.
It says that someone is installing cameras and security equipment without a license, but then it says a licensed alarm system contractor. Can you kind of draw me a picture of who and what?
So respondent makes bids, and included in their bids is the installation of security systems. For that particular act, they hire a licensed alarm systems contractor to do that.
They subcontract a licensed
Right,
alarm
and
contractor.
that's for discussion for the board. As I was reading through the case file, because it seems like they use this particular alarm system contractor exclusively, it almost rises to the level of a joint venture, and that's why I wanted to start with the letter of warning for the joint venture rather than a subcontractor, because I feel like that's more of a one-off rather than an established relationship that I'm going to always use this person. But I'm open to the board's interpretation of that activity.
So there's an unlicensed CCTV company contracting a licensed alarm company.
I'm not sure if they're CCTV, but I guess they sell this equipment
They don't have a license for nothing.
Right.
For
They
any of
don't-
our
They're not
stuff.
licensed, right, for anything under our statute.
They just hire a subcontractor to do it. And in their camera quote, they have a security quote.
Right.
By security, we're saying a burglar alarm type system.
Yes, sir.
So they're quoting a camera system and a burglar alarm system for someone else, for a licensed company to install, but the one doing the quoting and is not.
The unlicensed company.
Is the alarm contractor have CCTV on their classification on the license?
I believe so. I'd have to look at the case file again.
I don't know how their name shouldn't be on the quote, I guess is what I'm saying. It should be the alarm company should be doing the bid for the CCTV and the cameras.
What does this other company, the unlicensed, the respondent, what do they do? What is their primary business?
I didn't pull the case file. I can get my paralegal to pull that case file. But I believe they just sell the cameras, the equipment, if I'm remembering correctly.
And it may not really have any bearing. I guess I was more just trying to get a picture of what they were doing. If this is a HVAC contractor that's also trying to sell alarms, or this is a contractor that's building a house.
They do sell audio video equipment.
Okay.
So are they licensed to do anything that's regulated by this board?
They're not.
So they're going out and selling closed-circuit television and security systems, perhaps along with some other stuff.
Yes.
And then they're hiring some other company to do the installation.
Yes.
That puts them in the category of actually selling this, which would be regulated by this board, if they're going out and selling it. I think we probably need a little more information on this particular one.
And
Yeah,
it
if
would
it's-
even,
if
it would
it's-
even get back to the joint venture if there would be something with the other company involved.
I wouldn't necessarily see it as a joint venture, however, which was a question you raised. The fact that, and let me put it in a little different context. Say there's a general contractor. They're building a house, and they include a security system, and they include a closed-circuit television system as part of the overall general contract. And then they hire that work out to a licensed contractor. Then that would be within an appropriate relationship. And the fact that they use the same subcontractor on a regular basis would not indicate a joint venture. It's just that they use the same subcontractor, which is pretty common practice. But if, on the other hand, you've got a specialty company, say they do sound systems, and then they're also selling a customer a closed-circuit television system and selling the customer a security system, then they're actually doing the sale and then just parceling part of it off to a licensed company. I would think that improper. And yeah. So we kind of need to get a few more details on it. Maybe we want to skip that one and go on to the next one
I
and
think
come
she
back?
sent her paralegal after the
I'm
file.
going to get the case file.
So we're ready for number 5.
Okay. Case 2016-039-161. This complaint opened alleging misconduct by respondent. The complainant alleges that respondent canceled the monitoring service without 30 days written notice in breach of the contract signed between the parties. Complainant states that the breach in the agreement endangered his company. Respondent states that notice was provided to complainant that his account would be canceled due to his failure to pay the outstanding balance. Respondent indicated several instances wherein complainant made partial payments, if any, on the account, and as of June 2016, there was an outstanding balance of $831.24. Respondent states that attempts to settle the outstanding balance were unsuccessful. Finally, respondent states that following complainant's lack of cooperation and aggression toward respondent company, complainant's account was canceled and the balance zeroed out. Respondent included invoices showing complainant's outstanding balance, as well as correspondence from complainant to respondent regarding the discrepancy in balance due. My recommendation is to close as the matter is a breach of contract dispute.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 6 is 2016-039-961. This complaint alleges that respondent engaged in misconduct in violation of Tennessee Code Annotated 6232-319. Complainant alleges that respondent falsely reported time to his employer for which he received compensation. Complainant provided an agreement purported to be signed by respondent wherein he acknowledged the theft of time and agreed to resign from his position within respondent company and not work as a registered employee under the certification granted by the Alarm Systems Contractors Board. Respondent's registered employee license did expire on May 31st, 2016, and no new application had been submitted. My recommendation was to close and flag as respondent is no longer a licensed registered employee.
Motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 7 is 2016-040-441. This complaint opened alleging that respondent failed to submit a change of address within 30 days in violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069G. On January 29, 2016, the board office received return mail indicating respondent's new address. When contacted, respondent confirmed the change of address and indicated that the effective date for the change of address is May 2015. My recommendation is to issue a letter of warning regarding Tennessee Comprehensive Rules and Regulations 0090-01-.069G.
What's the time frame that they're supposed to report within? Is it 30 days,
30
90
days.
days?
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 8 is 2016-041-691. This complaint opened alleging that respondent failed to include its certification number on correspondence in violation of Tennessee Code Annotated 6232-316D. Respondent submitted correspondence to the board wherein the certification number was not included. Respondent apologizes for the error and has corrected the company correspondence to include that certification number. My recommendation is to issue a letter of warning regarding Tennessee Code Annotated 6232-316D.
Make a motion to concur with council.
I'll second then.
Motion by Mr. Harvey and a second by Mr. Cockcroft to concur with their council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 9 is 2016-048-211. This complaint opened alleging that respondent failed to submit termination notices for 2 registered employees timely in violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K. The board office received 2 termination notices on February 16, 2016, indicating termination dates of January 20th, 2015 and January 26, 2015. Respondent states the applications contained a typographical error and the dates of termination should have read January 20th, 2016 and January 26, 2016. My recommendation is to close as the respondent's explanation of a typographical error appears corroborated based on the board office's dates of licensure.
can make a motion, we concur with council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 10 is 2016-048-261. This is a consumer complaint alleging misconduct by respondent. Complainant alleges that respondent came to her home and sold an alarm monitoring service without fully explaining the service, or that she would be entering a second contract unrelated to her first contract. Respondent denies any misconduct as related to the sales with complainant. Respondent states that the welcome call survey was reviewed, and complainant acknowledged that respondent company was not associated with any other security company and had no responsibility for cancellation of her outstanding contract. Respondent provided a copy of the contract with complainant, which included a clarification questionnaire. Within the questionnaire, complainant acknowledged that respondent company was not associated with any other security company. She accepted responsibility for addressing any contractual and/or financial obligations with her previous alarm company. The questionnaire included complainant's initials by each declaration and her signature at the end of the questionnaire. My recommendation is to close.
Well, before we do, are you going to send a letter to this complainant?
Usually the letter,
explaining the board's action?
yes, we usually do send a letter to
That's a
the
civil
complainant.
matter
I mean,
versus what we.
yeah, I
do
agree.
with it.
This one kind of troubles me. I mean, it goes to some of what the new rules are about as far as the door-to-door sales. I don't understand how the consumer signed all these things, said all these things, but now they're saying they weren't told this. Did you have a voice recording? Did they have a recording?
I don't have a copy of the welcome call survey, but I do have a copy of the questionnaire and the contract that the complainant signed.
And she doesn't dispute that she signed this? Okay.
The complainant doesn't dispute it now, or
No, she does not dispute it.
the complainant now says different than what they complained about? Is that what I'm?
She's not saying that. She's saying that they did not fully explain it.
Okay.
Unfortunately, she signed a contract indicating that she clearly understood all of the terms. She initialed all of the declarations. I don't know that we can now hold the company responsible for her entering into two contracts when she has declared that she understood that she wasn't under an obligation, or that the company was not under an obligation to cancel her first contract.
And that's
As long as she acknowledges that she initialed each of those declarations, I think a letter of explanation that the board's not going to take any action on this should be sufficient for that.
I don't fully agree with that. I am concerned that the action here by the respondent is contrary to the spirit of the rules that and code of conduct that we incorporated recently.
I agree. That's this goes right to the root of that.
I believe so. Now, what action we want to take, I think the complainant bears some responsibility for what's taken place. If they've initialed and indicated that they knew this, then I think the complainant is not without blame. But this case goes right to the heart of what we had instituted in our code of conduct rules.
I'd like to know more from the complainant. If the salesperson went in and said, sign here and check all these things off and doesn't explain anything, I'd like to know if verbally that was the same thing that took place. Because it's just hard to believe that the person signed all this paperwork with all of this stuff saying that they didn't have a contract, they didn't have another alarm, and we've heard this numerous times, and sometimes there is even a recording where they've supposedly said they understood that, but I guess it could be buyer's remorse, where down the line they're saying they don't want it, but.
Or that should be part of the questioning with the investigation on these cases, so that we don't.
We need to start finding out, I guess, like, did they present the card with their business card with their name, their license number, to present themselves as the company they said they were? I mean, that's.
And in this particular case, all of those were, like I said, they initialed those declarations that she knew this was the name of her company. She knew, well, the company that was selling her the new alarm. She knew that they were not affiliated with her previous company. But if there's additional investigation that the board would like me to do, I can definitely send that out.
All I was suggesting is in the future, maybe that just be part of the investigation is in that line of questioning, you know, were they harassed or were they asked to do something they didn't understand to go along with the new rules that we're speaking of here.
Because this is a situation where we're really trying to protect the consumer. I would, Madam Chairman, I would make a motion that we send this respondent a letter of warning outlining the new rules in the Code of Conduct, which may not have been in effect at the time this transaction took place anyway, so that the respondent company would be aware of what our rules now encompass, so that we would perhaps not encounter future problems of this type. I think we need to send the respondent a letter of warning outlining the current rules.
This happens so much. I hear it. I'm sure all the other contractors do too. When you go out on a new job site, they tell you what the other contractor did. And if we were to go over all these cases, we would be here every day, just going through these cases and doing their investigative work.
Madam Chairman, let me rephrase that. Rather than call it a letter of warning, let me suggest we send them a letter of instruction, so that they would be, because, you know, the respondent company here certainly doesn't feel like they've done anything wrong. The complainant is unhappy, but she's complacent or complicit in what has happened here. So I think that a letter of instruction rather than a letter of warning would be a better way to term that.
Is there a particular instruction? I guess I'll let the motion go and then I'll ask my question.
No, I would just change the wording from a letter of warning to a letter of instruction.
There was a motion before that one, though. All right, with council.
Oh, you're right.
Yeah, but did it get seconded?
No.
Motion seconded.
So you want to propose a new motion?
I would
or
make a motion that we.
Keith or Ken, which
you
Oh,
one?
no, I'm good. I just want to make sure we didn't skip over it.
Okay.
Thank you. You're right. I'd make a motion we send the respondent a letter of instruction, making them aware of the new rules, and so that perhaps they could preclude some of this type of unhappy customer in the future.
Does that really help the consumer at this point, though? And I guess this consumer still left an issue if.
From a consumer standpoint, it's still a civil matter from her contract.
So do we have a second to Mr. Roberts' motion?
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to send a letter of instruction to the respondent in this matter. And then, of course, there'll be a letter go to the complainant explaining the board's action. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Just
Go ahead.
before we move on, in the letter of instruction, am I specifying any particular part of the code of conduct or just the contracting with customers portion? Am I trying to bring that to the respondent's attention, or what am I actually advising them in that letter of
I
instruction?
don't know that the whole code of conduct, but I mean, if you want to include that, I think it would be okay. But I think more specifically, the new rule about is it the door-to-door sales? Is that
There is a
tax?
door-to-door, and then there's also 0090-06-.04 titled Contracting with Customers.
I think both would be applicable.
Okay.
I would think that we would want to point out that they need to more fully explain the terms of the agreement. My guess would be that the contract, well, all these things were checked off and it was pushed in front of her to sign, or he
Oh,
or
it
her.
says she initialed by each declaration. That's what I kept questioning Ashley. Was this just a checkoff form that she signed in mass? But she actually initialed beside each declaration, so if she failed to read it, which, you know,
Yes, so-
It probably still was, I mean, I'm making assumptions here, but
Yeah.
when it's, I just don't see how the consumer did it, other than if it was strictly she changed her mind, he or she changed
We're
their
gonna have to
mind.
be careful with it. If this was anything other than a letter of instruction, a letter of warning, if there was a fine attached to this, and then we had to go to a formal hearing, we are talking about a contract dispute that you don't
No, that's
have
why
the
we're not
authority to
taking
enter
any,
into.
it's just to bring to that company's attention about the rules, especially the new rules on this.
But then, what did the company do wrong?
My guess would be they didn't fully explain the agreement. They probably presented paperwork and said, here's all the paperwork you initial, here, sign here.
And how do we stop the next person from doing that?
I don't know, but that's what those rules were supposed to do. That
Oh,
was part of
no,
my
I don't
frustration
think
with the
so.
rules.
I disagree with that.
We'll be here all day if we start doing everybody's investigative work.
I think we've taken appropriate action to let this company be aware that perhaps they need to be a little more careful. It would appear to me that we have an unsophisticated customer here that was just not very aware of some of the ramifications of what the customer was doing. So I think, again, I think our action is perfectly appropriate.
Okay, number 11.
Case number 11, 2016-049-691. This complaint opened alleging that respondent failed to include the company's certification number on correspondence in violation of Tennessee Code annotated 6232-316D. The board received a letter in connection with the registered employee application, and the letter did not include the company's certification number. Respondent states that going forward, the company will include the certification number on all correspondence. My recommendation is to issue a letter of warning regarding Tennessee Code annotated 6232-316D and close.
I make a motion to concur with the recommendations of our council.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 12 is 2016-052-571. This complaint opened alleging unlicensed activity by respondent in violation of Tennessee Code annotated 6232-304. The complaint alleges that respondent is providing a large network fire alarm system in Tennessee without being licensed by the board or as a general contractor. Respondent, an out-of-state company, states that the company was hired to find qualified licensed contractors to work at the Tennessee facilities. Respondent states that after proposals were submitted, the company selected the best licensed contractor. Respondent states that the selected company presented the license, insurance, and the activity was confirmed with the board office. My recommendation was to close as I did not see a violation alleged.
So the out-of-town or out-of-state contractor, the respondent, didn't do any work. They were helping find a contractor in the state? Yes. And all the work was done in the licensed contractor's name?
That's correct.
In essence, they came to help them shop for a security system?
Acting as a consultant, it would seem.
Except they turn in an estimate first.
Person that was consultant turned in a quote?
No.
They didn't. The responding company was hired by Tennessee Company to get the bids to install that fire alarm system, and they received the bids and picked the best person for it, and they received their license and they
License companies who submitted the bids. Then.
right.
Okay.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 13.
13, yes, is case number 2016-051-381. This complaint opened alleging various administrative errors by respondent, including operating business without a designated qualifying agent since February 23, 2016, failure to certify its branch office, failure to register employees within 30 days, and operating under a name under that which the company was certified. So that probably should say other than the company that it's certified under. Respondent has settled a prior complaint and is in a payment plan currently. The instant complaint is the result of the respondent's compliance efforts. The board office received a designated qualifying agent and registered employee application for respondent company in September 2016. However, the previous designated qualifying agent left the company in February 2016. Respondent also uses a name and location other than the company name and address which is certified. Respondent did submit an application in order to obtain a designated qualifying agent and added a DBA and address to the company certification. Additionally, respondent indicated that all clients have been informed of the company address change and DBA. My recommendation was to issue a letter of warning and close.
They move, or do they have two locations?
They have two locations.
So they can't really add an address, can they? I mean, they can't have more than one.
They didn't move. They still have the Nashville. Oh, okay. So they have moved. At one point, they had two addresses that had to be posted. Conversation. Okay.
Let me try to help
I'm not
us a little
clear
bit
on
here.
this one.
Okay. This individual did come into the office and speak to us. Actually,
You're going to have to speak into the microphone.
well, I am. It's just not working. Did come in and talk with us about this, and there was a civil penalty assessed, and then there was another very, very large civil penalty assessed. What happened in the office was we didn't attach this one with the second one that they have the payment plan with. We want to
This
actually
is some
incorporate.
cleanup to the other.
Yes, to the other two that we have already settled, and they do have a payment plan on that large one.
Thank you. That makes a lot more sense then.
But they're working, according to the wording in this, they're working diligently to bring everything into compliance, correct?
That's correct.
Madam Chairman, I make a motion that we concur with the recommendation of our counsel here.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
I believe we just have to go back to case number 4. So respondent company is giving estimates for home automation systems. And for the security portion, he contracts out to a licensed alarm systems contractor.
Define home automation. Home automation.
That's the only information. That's the only information he gave about what his company did versus what the licensed contractor does.
Typically, home automation would be lights and thermostats.
Door locks, things of that nature.
Cameras.
So the bid includes audio locations, TV locations, and then there's a security systems line, a cameras line, and then in-ceiling speakers for all audio locations, pool audio, surround system. Those are the things that are on the bid. And for the cameras and security portion, they used an alarm systems contractor that is licensed by the board.
They didn't put a security system in?
Sorry?
They didn't put a security system in, they just put cameras?
No, the security.
The security system is listed on the
From
bid as
the-
well, but
Oh, I didn't
for-
hear that part.
the responding company did not complete that installation. That's what they hired the licensed company for.
They're not licensed as a general contractor or something else?
Not that I know of. No, they're not, I'm sorry.
Based on the information that, and my understanding, the information you've presented, what this company is doing is they're going out and selling a home automating sound system, they're selling a security system, and they're selling closed-circuit television. Then they're subcontracting out the installation of the closed-circuit television and the security systems. But that, in my opinion, would be in violation of our ordinances, because they are in fact going out and selling the security systems and the closed-circuit televisions and then just hiring somebody else to do the installation. And that, in my opinion, would be a violation of our ordinances.
I think it is a violation of the ordinance.
agree.
But I think the one difference in what you might have stated, I think their feeling, the reason they feel it's not is the licensed contractor is billing everything, but the way you said it, they were subcontracting. I think they're actually selling it and the other company is probably billing and doing everything in their name, the licensed company, but that's still a violation. But that would
But
probably be
it's
their
not the
response.
general contractor.
Right, they'd have to be a general contractor to be
Right,
able to
but
do
they're
that.
not. They're a home automation, but yet they're selling cameras and security. But then contracting with an installer, they're selling the equipment and they're not licensed.
If they
Is
did
that
it the other way
correct?
around, it'd been different. If the security company had subcontracted the home automation company, they'd been all right.
It would be my impression that this respondent company needs to be licensed to sell closed-circuit television and security equipment.
So,
Because that is apparently what they're doing.
so is your letter of warning going to,
Yes, it could be for the unlicensed activity it can be a letter of warning for that. Like I said, I had it as joint venture, but if we want to warn them as to the unlicensed activity, we can do it that way. If you think that this rises to the level that requires a civil penalty, of course.
Did the complainant say these two people had done it many times?
The complainant is a competitor,
the complainant's what, hon?
a competitor. So another licensed contractor.
Do they have proof that they've done it many other times besides this one?
The statement from respondent's witness indicates that they've done this previously.
We wouldn't
This
find them
in
for
their bids
unlicensed activity?
and contract.
I don't know that a letter of warning would be
I don't think it's
fitting
enough.
for this situation. This seems to rise above just the,
would make a motion.
I'm inclined to agree that I think this rises above just
Yeah.
a letter of warning.
yeah.
Both the licensed company and the unlicensed company.
I don't know that the licensed company, again, based on the information presented, it would not seem to me that a licensed company is doing anything improper if they're acting as a subcontractor on doing the security closed-circuit television installation as a subcontract. They're probably not doing anything improper. If they are, in fact, if it is a joint venture and we don't have information on that, one way or the other, then we've got a violation there.
All we have is the statement from that licensed company that says that they are contacted by the respondent company, and they estimate the cost to provide the security systems, and then that is included in the respondent's estimate to the customer.
I didn't mean the licensed company. I meant the unlicensed company is who I would make a motion that we fine them for unlicensed activity.
You could, if all the work's being done in the licensed company name, you could almost say this was like the other one where the out-of-state company was being a security consultant for the people. I don't think that's really what's being done here. I don't know that we have a clear picture of, are they really dealing with the licensed company or not, or, I mean,
I missed
the
the
end
first part of your
user.
question.
You don't think the home automation company knows they need a license, so they're going to subcontract it out to somebody that does have one?
It sounds like it does sound like
By
they're trying to
going around the law?
subcontract it. Yes, it sounds to me like some sort of a joint venture. it's hard to tell from the information we have whether or not the license company is at fault there or not. If it's truly that someone just calls up the license company and says, can you do a quote for these people? And then all of the business is handled by the license company didn't do anything wrong. But it sounds like there's more to it than that, like there's an ongoing relationship.
By what we have, I will make a motion that we find the unlicensed company, and then we'll get more information, I promise you. If nothing's going on, they're going to call and say, hey, wait a minute. The broader picture.
From the unlicensed company. Okay. As far as unlicensed activity, is the motion to include a civil penalty in the amount of $500 or $1,000? And I say $1,000 because statute says $1,000 for unlicensed activity at a minimum.
Decided on those without making further reductions because that was adjusted several years ago, I believe. I don't know. Excuse me, I'm reaching out to you because it seems, I know we're saying that the licensed alarm company isn't doing anything wrong, but I would hate to see that company continue to be involved in activity that's not above board.
To include the licensed company, we would have to establish a separate complaint against them and investigate their dealings with this unlicensed company further to pull them into this particular violation under this complaint. They did not have a proper opportunity to respond or offer a response. They offered a statement as a witness to the respondent. So I would say if the board is curious as to the licensed company's activity, that's a separate complaint, separate and apart from this particular one we're discussing now.
Madam Chairman, I make a motion that we authorize a formal hearing, but would authorize a settlement of this with a $500 civil penalty for engaging in I'm sorry?
It's $1,000.
That's statutory?
It is.
Yes.
All right, then we'll make it $1,000.
Okay, and continue.
For engaging in unlicensed activity.
Haven't there been other cases where it was done at a lower amount?
The statute says it's $1,000 a minimum.
And I've wondered about that. But I thought there were some other fees that were, or some schedule.
You have a fee schedule here, but it's not for unlicensed activity.
Okay. I was thinking that there had been some that
Okay.
were less than that, but.
Do you have anything else on your motion?
No.
We have a motion by Mr. Roberts to authorize a formal hearing with a consent order of $1,000 civil penalty for engaging in unlicensed activity. Do we have a second? Second. And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Now, does the board wish to open a complaint against the alarm company that's involved with this unlicensed activity?
I don't visualize in this situation particularly unlicensed activity on the part of the licensed company. It might be worth a little bit of further inquiry, a little bit further investigation as to the relationship between the two companies, but based on the what's presented here, I just don't see that we have any reasonable indication of unlicensed activity on the part of the
Does this
licensed
require a
company.
complaint being opened?
This would require a complaint to be opened for me to get on the phone and call these people and ask them about this.
What I said a minute ago, did anybody want to propose a motion to open a complaint to investigate the level of activity of the licensed company in with the unlicensed activity?
I think they'll drag them in if there's a civil penalty in it. And they go talk to them. Don't you?
I do think that probably would happen, but I do think that we should still look into it. Is there some issue with opening a complaint? If you look into it and you find there isn't a violation, we can still close it without any prejudice against them, or?
If there's no violation found, of course, we can always close that complaint.
I guess we're hesitant to say we want to open a complaint.
I do have the authority to close it administratively, so it would never be presented to you.
And with that understanding, I can make a motion that we open a complaint against the registered company here that would be based on them engaging in a joint activity.
Okay, we have a motion by Mr. Roberts to authorize a complaint to be opened against the licensed company to determine their level of activity in a joint venture. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
Aye. All opposed?
I forgot to say aye.
The motion carries.
After a lot of conversation, I think that'll conclude the legal report.
Well, thank you. You did an excellent job.
Thank you.
Okay,
Madam
let's take a
Chairman,
break.
Madam Chairman, before we do that, let
Yes.
me take just a moment to compliment our legal section. I think TCC is doing an outstanding job, and I for one would just like to recognize the hard work she puts into this, and I think it's exceptionally well done. Thank you.
And the fact that she stuck with us for more than 2 months, too. Okay, we're going to take a 20-minute recess.
Say that too loud, they'll take her away.
You may be
Go
right.
ahead and get somebody else.
Okay.
We're going to call back to order this meeting of the Tennessee Alarm Systems Contractors Board. I think we're going to skip down to Exhibit E on our agenda.
Oh, it's under E. It's not E, it's Mr. Hartberger, Assistant Commissioner of Operations, Technology Changes and Licensing.
Okay, it's beneath Exhibit E.
Exhibit E,
It's
yes.
an individual entry.
Right.
Mr. Hartberger, would you like to come forward and address the board, please?
Members of the board, I'm here today to talk to you about licensing and what the
Might want to sit down at the mic over there.
I'm here to talk to you today about the future of licensing. We have seen over the course of many years that licensing has changes in the certificate and the need for the certificate. And so every individual board that I've spoken with have unique needs for it. And so what we want to do is we want to start a dialogue. It's not here today to suggest to you that we know all the answers, but the point is to come and talk to you and start a dialogue and suggest to you a couple things and to show you a couple of items and see where your mind will go with that, and making sure that what your rules are and your statutes and all those things are all aligned to be able to leverage some of these technologies and some of the technologies I'll show you today. My point is to show you this, not to say this is the answer, but it's to show you this purely to be able to get you to think about what the future might hold for you. Is that okay with you?
Sure.
So if you want, I think you have the paper in front of you also. So if you want to know the first couple that we're going to do, if you look, this is the one that we're going to look at. It's the one that's the old style. It's the one I'm sure you're very familiar with. So it did work. That is a lovely photograph taken on the floor of my office so that we get the flavor for this. Is not high tech. This is a piece of paper, and it's printed on a form. And if you know anything about protected forms, in the past, protected forms were difficult to reproduce. There wasn't the technology that exists today. Today, so that you understand it, I can take this form, go to my house with a inkjet printer and some simple software and produce one of these that's indistinguishable to you from the one that you're looking at in front of you. So in the past, this was considered a security measure. If you look at the form, you're going to see the word void. If you get the right angle, you're going to see the word void in it, so that if it were photocopied, that used to be the height of security for a form. Today, it is not the height of security because, as we said, we know people that were manufacturing license, I believe it was for manicurists. They literally used Microsoft Excel and a color printer, and they were producing these, and they looked better than the ones that we produced, to be honest with you. They actually had better coloration and better uniformity to it. So it was actually better in their case than the one we have. So this is where we start today. Where we want to start to go to is the beginnings of something that can be automated and something that can be leveraged. People do not stay in their office. People are out and about all the time. So we need to get to something that's mobile. So I'll tell you that at the beginning, that we're wanting to look for something mobile. But as a first step, we need to get to a different style of license that is more legible when someone walks in. If you look at the previous style, you very quickly see that it was, did I pop too far? The previous style, which is this paper one, I'm sorry. If you look at that style, you'll notice that the fonts are difficult to read. If you're very far away from it, you in many cases can't read it. And again, it was kind of in the day of 1980 was probably thought of as the height of something that looked and was aesthetically pleasing. And then today what we're trying to go for is something that is very simple and straightforward. And so this is a prototype. This is not the end result that you would get to, but it's a prototype of something suggesting let's use cleaner fonts, make it more legible. And if you'll look at the area on the form, where's the laser pointer on this one, ladies? Here it is. If you look at this area on the form, you see a lot of blank area. And so what we're trying to do is thinking in terms of how do we create a form that can be used uniformly amongst all the alarm and associated people. And so anything that would be unique to you would be located in this area. And so then you'll also notice this code over here, and I'm going to talk about that in a second. But initially, we would probably print this here and send this to you, and it would be on the exact same stock that you get today. So as you're looking at it, you're looking at this form. So it is something that provides us with a different methodology to print and something that we can actually get. The state has a requirement that any form that we send out must go through a forms committee. We can create one form that can be used uniformly across all boards. Now the next thing, and it's something I'm actually working on and excited about personally that we're working on, is the next step is, do we need to print this here and stick it in postal? And then we actually have had many issues over the last month and a half or 2 months between state postal and the U.S. Postal Service, things getting really slowed down, and something leaving here that you normally expect to be there in 2 days, 3 days tops, being a month. And so in many cases, there were people calling and getting duplicates, and there were times like maybe 4 or 5 duplicates on some of the boards, and then literally they all would show up on the same day. They got backlogged somewhere in the postal system and would show up. Depending on the type of permit it was, some people were not allowed to work as a result of that not being there. Don't know if that would impacted folks in your board, but it did impact others. People would refuse to let them work without this piece of paper in hand. So we're wanting to get to something that goes beyond that. So the next step, and it's something I am working on, is take a look at this piece of paper. This would be something that you're going to be able, and could be able to in the very near future, be able to print at your office. So you go in and renew your license, or you apply for a new license. When that process is complete and you paid your fees, and if somebody's got continuing education, there's a bond requirement or whatever may be done, when the person on Cody's staff hits the button that says approve this, what if you get an email and this is what was attached inside the email? And so that you know that that's not too far away, it's something I'm doing here in a test mode, that we are doing this today, that we're able to send this and it shows up in your email account. So all you would have to do is go into your VO account that you're aware of, that core VO account, and you would select a little switch that says, I want to be able to receive documents in email, and it's got a field that says email address, and you would put in the email address that you want to receive these documents, and from that point on, any document that we deemed the ability to send you electronically, when you said that you wanted it, it would show up in your email account. So now you're not waiting for days or weeks or whatever to get your license. Your license shows up from the time that it's approved here. Maybe within 10 or 15 minutes later, it's showing up in your inbox for you to be able to print. Some professions, in terms of what they want to be able to produce and put in a frame, may or may not be suitable for the kind of paper I showed you today. There is paper that we would recommend that you potentially go pick up that's a little heavier cardstock that you could put in your printer if you wanted something that was just a little thicker so that you could put to prominently display it. One of the reasons that we, at this point in our testing, have limited it to a small amount of color. If you print it on this kind of paper, if you put a lot of color, the paper will buckle. I don't know if you were familiar with that. Have you ever printed a photo on plain white paper and you see it all puckers up? Well, so that's why we've limited it. The amount of color on here is so that you will be in a position to print it and not have it do that to you. So again, this is a prototype that we're looking at, this particular form being something that we would be able to produce here in this form, still on the same old cardstock. It produces it in grayscale, but then when we allow you to produce it in your office, that you have the ability to have it pop up in color with just a little splash of color for you to go in a frame. Something even a little bit more exciting, I mean, I could show you my phone, but that same certificate is, you can see it took a photo of the phone. It shows up on the phone. It fits nicely in one of the phones for someone to be able to show it to them.
They work on flip phones?
There's no good answer for this. No, they don't work on flip phones. You need some type of smartphone to be able to display it, so.
Paul, let me ask you on this one here that you handed out, the paper one. Where is the photo going to go?
No, we did not, in this particular case, we didn't save a lot of space, but the photo would go, actually, we would move it around to be similar. And if you line those up next to each other, you can see that the photo would still go here in the same spot. We've left space for it. It's not perfectly spaced out.
Okay, I see.
Yeah. And so we are actually working on being able to take the photos that are sent in, and the photos will be scanned, and they actually would print directly on this piece of paper. And in those cases, it's the case very specifically that we would recommend that you get the thicker paper, so when it prints, it would be sharper images. We still okay? Pass still? I'm sorry. Yes, we're going to attach the form, the photo that you do, and then when this prints, it would actually print in this area. And again, you would want to use probably a little heavier paper so it did not pucker and distort the image. There's paper that's maybe a dime a sheet that you could print those on that would do a really nice job that you could then cut out. Either choose to laminate or not laminate, or stick it in one of the little holders, and it would work great.
This is more secure.
We're going to go into a little bit more of the security, because the point is that what you have today is not secure. And so what we want to do is we want to go to some steps that give you a little bit more security. And so I purposely not mentioned this little code down here for a second, but so that's where we're going to go next. We'll go to it's called the QR code. If you're ever interested in it, if you have the iPhone and the Android phones, the one I use is one from a company called QR Reader. I'm not endorsing it. It's called QR Reader by a company called Scan. And you can find it. And it works really well to scan these codes and pull up the information. So now let's talk a little bit more about security. Something that we can do with security to make this work better is both from the phone or from the printed document. What if someone can walk up with a phone, have a little app that we just mentioned called QR Reader, pull it over the barcode, and it sits there for a second, and the next thing that comes up is this on their phone. And it's actually information about that licensee as of that minute. So it's got their license status, their effects of the expiration date, the original date, the names. And in this particular case, it lists their specialties and goes a step further. And so are those actually listed on their paper certificate?
Yes, that would, when you.
So in this case, whether you be looking at that phone and someone scanned that, because you actually can take the phone and lay it on the table and take another phone and scan it. It'll scan the code, and it immediately, the Verify application, are you familiar with the Verify application? It goes to the Verify application and looks up this individual and takes you straight to this page, which is the information about the licensee that would have been on that page that are reflected of that QR code. So the security that we're trying to build into this is something, it's completely easy to take any paper form and duplicate it. And so what we want to do is give something so that if someone does duplicate it, when they create that QR code, if the QR code doesn't match who you're standing in front of, and it pulls up another licensee or pulls something that says this person expired 2 years ago, and I'm looking at a piece of paper that says, well, their expiration date is a year from now, you know that it's been tampered with. And so what we're trying to do is be able to get people to utilize what is in everybody's hand today, which are mostly smartphones, few flip phones. But put something in their hands so that we can leverage the technology on site, whether it be in the field, if it's an employee, could be scanning an alarm system employee, or it could be the contractor, the main contractor, whoever. But when they scan the code, it's going to go straight to the database and tell you about them. Other items that we've talked about, and obviously it'll be a board decision or other decision all over the place, is also on this same screen, potentially listing disciplinary actions that have been settled, that it lists any disciplinary action. So if someone has been disciplined, someone scans that code, it comes up, lists information about them, lists their specialties, and then right below that lists one line per each of the disciplinary actions that have occurred. And with potentially the ability to click on any one of them and see more detail.
Now, that's assuming that you have internet connectivity when you scan the QR code.
Yes, sir, that is assuming that you would have internet connectivity.
We do have some where you don't have that connectivity, but yeah, I just want to make sure I understood that correctly. Thank you.
Yes, sir, and it's why that you're going to, for the foreseeable future, you're going to remain with the ability to be able to print your document so that you have a document that you could carry with you. So in a situation where that occurred, that you would be able to rely on that.
If it's an expired license, it would pull up something showing void or expired. I tried the code just now, but it took me to the search page on this generic one, but it didn't show. It just took me to the generic search page.
That's what's coded on this QR code, is the ability just to get you there. We do not have it coded to a specific business at this point. I don't have it coded there. But each one of these on every license would be a unique QR code that when you scan it, would take you straight to the screen I'm showing you. It would take you straight to that type of screen.
And even if someone didn't have internet connectivity, it's not worse than, it's as good as what we have now. So if they have internet connectivity, it's so much better.
Yeah, absolutely.
Not to get really technical with it, but you can actually take a photo of this. You can use that app I was telling you about, QR. If you're not connected, you can take a photo of the QR code, and then when you get back in range of internet connectivity, you can say scan it now, and it'll actually go through and do it in hours later whenever you get back to someplace.
I like all the benefits of the electronic aspect. I know Cody probably like us to only do that, but I still think we're going to need cards. But maybe eventually we won't. But I think for the short term or the near future.
Well, why would you actually need a card if the individuals you're sending out to my home has it on his telephone, and I'm a savvy consumer, I'm going to ask for an ID, and he's going to show it to me. You give him an ID anyway for your company. He probably wears your company ID. He's got mine in his back pocket in his wallet.
Well,
just
I
a
guess
card.
we would have the option that they could print it themselves and laminate it if they wanted to. Because you would have the issue where someone may not have a smartphone.
Well, now, what we're talking about, don't all these cards come to the company? So you're not talking about Johnny sitting at home doing it himself.
Well, they do now, but, you know, I'm not sure how the new registration terminations are. I don't know how they're handled. Are they sent to the company?
Everything in your case is sent to the company except for criminal histories. That's something that we might want to take a look at this, and with this technology that's coming, we may want to look at something now.
Well, isn't this
handled
up here at the
differently.
top, can that be, with the ID, couldn't that be used as
Right, they could still
hard copy
print it,
ID?
cut
That
it
is
out,
the-
laminate it.
That is
I mean,
part.
he was saying, you know, if somebody didn't have internet connectivity, you would have this that you could issue to or give out to a registered
Back up.
employee, yeah.
And so what I've talked to Cody with on several occasions is, and we're working on it, to take the photos that they send in, scan those photos, and actually print that all in one shot to that card. And that's where I was suggesting that you might use a heavier card stock. When you know you're printing those, you put the heavier photographic style paper in. It prints on there and gives you a much more durable and clean image.
I always think about people my parents' age in their 80s. They don't have internet connectivity. you were to ask my dad what a QR scan was today, he'd look at you like you'd grown a third eye. So, I think about older people that still want to see an ID. I like the format. I think it's an excellent idea, especially if you have the photo. But I still think that needs to be implemented and not rely on just that. A lot of our alarm systems are with the elderly, and I think about them, especially with my parents.
Don't understand that because Johnny's going into the home. What difference if it shows you a card or shows you on telephone?
Right. And we do have the option to still print the card. When I first started saying
Yeah.
something, I didn't
When
think
you
about
get
that,
to
but-
be 86, you'll understand, and that's all I'm going to say.
I'm pushing that myself, but
Well, when you get to be that age, you'll understand.
But it sounds like we would still have the option, the company still has the option to print a card out, and I don't think it's any less secure than this card, because this one can easily be duplicated. And because we had complaints, we've had issues where that happened, so.
And if we're dealing with the photographs and the photographs being printed on the card, which I think we really need, would it be possible to also incorporate that in the online so that when they pulled up when they ran the QR code, the photograph would show up there also?
let me interrupt. Why do we need the photo? You've already got their ID on, I'm just asking a question, because it's in the statute, I understand that rule. The man from, say, Comcast comes to my house, he doesn't have that photo ID. I don't ask to see that photo ID. So my question is, why are we putting photos? Who does that benefit? They've got the ID in the back pocket. They got your tag on that says, I work for this company. So why are we putting a photo on it?
I think especially for an unsophisticated customer, and I keep thinking of the lady that we dealt with the complaint a little while ago that initialed everything and was paying no attention to what she was doing. We've got some very unsophisticated customers out there, and they're going to look at that picture. They kind of like indicated a minute ago. Some of them wouldn't have a clue as to what a QR code is, and they're using my wife uses a flip phone. She wouldn't take anything for it, So the flip phones are out there, I know.
You get parts for about another 6 months, and then you're going to be out of luck.
Then I'll be in bad shape. But anyway, the people like that really look at an ID and say, hey, yeah, okay, that's who it is. And when they see the person's picture on an ID, that probably means more to them than anything else. They probably may not even know it's a state of Tennessee because they see the picture, and that just provides some reassurance to the customer. I think the photos are significant. Now I know they're a lot of trouble, and especially one of the things that would be, I think, very helpful if we could submit the photos electronically rather than sending in pieces of cardboard with a questionable photograph on it that has to be hand snipped out and scanned and all that here. If we could,
Well, I'll interrupt you there and simply tell you, yes, sir, that's the way we're going. You will be doing your applications online. There will be no paper applications, and you will upload your education, your photo, whatever document that you need to send to us. You have to do it online with the applications and on your renewal. So that's going to
that
take
makes
care of that.
perfect sense, yeah. But so that you've already got the photo in electronic format, it'd be easy enough, I would think, to include it in the we want it on what's going to be an ID card here. But I was just wondering if it could be included in the
I will take it
information.
down as a suggestion and see what we might be able to reach across there to be able to find that information.
Yep.
Are you saying, I'm sorry, I just can't get it straight in my mind. Are you saying you're whatever you call that individual goes to the home, they knock on the door and say, hey, I'm Johnny Smith from ABC or whatever, and then they whip out their little state ID and say, here's my picture? You always use your ID when you go knock on Mary's door?
Theoretically, I think you're supposed to.
Supposed to be
It's not in
supposed
the-
to have it,
I
yeah.
just wondered,
And the
you
code
know,
of code of
because I don't
conduct,
hear
code
that.
of code of conduct, code of conduct says they have to present it.
Let me,
I'm just
one other
asking,
thing
'cause-
on the license status, as long as it's active, black is okay, but if there was some type of revoked, suspended, or whatever, could that be changed to red so that, well, I mean, it would just draw someone's eye to it that there was, they weren't active.
No, a lot of small companies don't have their own IDs. I mean, you're talking, some of the large national companies have a company ID that has a photo ID, but we have a lot of small businesses that are licensed in the industry that don't have their own company ID per se.
This is where I speak up and say, in my office, I'm dealing with 90 to 95% versus those 5% that don't. And this is the way that we're going to hopefully proceed in the future. And if it means doing seminars and trying to educate or get out of news media, to get to the news media, whatever, how this has to be done, I think that's the direction we're going to have to go into. Yes, sir, you're right. We do have companies who, I've got several guard companies, for instance, don't even have a fax machine yet. Well, they're really out of date, but I have to deal with that other 95% that do.
Spoke with a couple groups and people in just general, if you read literature, some individuals in some areas are requiring driver's license because it is one of the few IDs that they spend a lot of money. Forgeable as you can possibly get it, and so there is some thought process that I've read about asking that people would show their driver's license, and so.
A more secure photo ID, and then just have the other as a companion.
Some of the case studies I've read about using that, it's a state-sponsored ID. It's got a great photo. It's difficult to duplicate in a home setting. You can send it to China and get it duplicated for $1, but other than that.
Well, what you're proposing here, printed in your office, would be easily forged and duplicated, probably a little bit more so than what we currently have, but I don't think significantly more so. It would be easy to take that and basically copy it, reproduce it, put a new QR code on there, but the QR code would be invalid. But that wouldn't bother my wife with her flip phone. You know. No, I don't see that what you're proposing would be any significant problem. Like I say, I think to me probably the thing that would be the least convenient was now when we get the cards back, they're laminated, and with this would be print them there in our office on whatever paper we happen to have, and unless we've got a laminator, we don't have laminated cards, which are. But on the other now. Will these be able to be printed more than once? In other words, if you send me this online, can I print 3 copies of it or 5 copies of it? Give one to each employee?
We couldn't lock that out.
There is a. We have to explore that.
I'll say again, it wouldn't be anything to keep me from printing off 5 of them.
Right.
I just can't see that would be a.
But if we got photos on them, then printing off 5 would be a little more challenging. It wouldn't have 5 different employees with the same photograph and long hair.
Don't you think the person that's going to print it out multiple times would also be the same person that would just forge it? I mean, it's not. Right.
Are you going to do like a consumer affairs campaign to notify the public of the changes that are coming so they'll know to look for this QR code, scan code versus?
You're going to do that. No.
I didn't know if y'all were changing it across the board.
I kid when I say that because I actually was the IT director here for 12 and a half years. And so, of course, I would not have done that. But now, as an assistant commissioner of operations, I would absolutely be involved with Cody and the team as we tried to put something together to.
I'm sure we'd be doing something of that nature because this is going to affect all the programs that are under our supervision.
But I was just thinking on the state website, if it was at a less specific group than just the Alarm Systems Contractors Board, if you're making these changes system-wide, that perhaps it needs to be further up on the website, where the consumers would come to that before they would the boards.
I think you would have to do something like that. We would obviously work on that, but
Yeah.
Something that would be generalized to gather people's attention and then try to funnel them.
That's what I was saying, not wait till you get down into the specifics, but have something further up on the website, so that it catches people's eye when they first go to that website.
This change is going to affect all regulatory boards.
Yeah.
Yes, I'm sure we will be doing something on the website. I have asked for years to have flashing red or something to get their attention right then, other than going down in and wait till they get to the alarm board.
That's
Or
exactly what I
whatever.
was saying. If you have it at a higher level on the website, before you start going into the particular boards and licensing sections, then they know past that point, they can't get to this point unless they see this banner first.
The way the internet works today is that most people arrive at pages via Google or something similar to it. That way, if you were to search for alarm contractors, it's going to probably take you directly to your web page and bypass all those intervening pages. And so that's when I mentioned it being multi-layered. You're going to need that to be on all those levels. So if you land at commerce and insurance, or if you land at regulatory contractors,
It's there.
it's each one of those layers is there, or points you to something that you can see.
Yes.
I don't know that you've noticed that the online capabilities that we have, we've recently added videos. When you go to the VO page, main page, to sign up for a new account or to renew your account, over on the right-hand side, at this point, there are 3 videos that we've linked to. And so over time, there will probably be instructional videos for something specific like this. So if someone was going to be instructed, I want to receive my license via email, as opposed to printing it and having to wait for it, there would probably be a video to say, if you want to start that process, go and click this box that says receive via email, and then go to this field that has the email address and use an email address that you want to receive that style of document from. And then from on, when you go in and say print the document, it's going to act like it's printing, but it's going to email it to you as opposed to printing it here, having to be full.
Is there a significant expense now in making the cards? I mean, would you have a savings if you didn't make the cards? Is it?
Yes, whenever you consider everything, the biggest thing is the employee time. And then, of course, IT, they have to actually print the certificates. You have that expense. And you come into my office, I've told you before, we have to cut the photos out with a pair of scissors. And then we have to do the two-sided tape. Then with Laminex, the only way you hold a picture onto it, so it's very labor intensive. Then you do have the mail.
You use a flip phone too?
I have gotten rid of my flip phone. I have an Android.
But here was where my thought was going. If there's a difference in cost, if either the registration fee could be lower, or we charge more, or charge a fee for having a card, if 95% of the people wouldn't print the card, wouldn't want an actual card, but for that 5%, if they could check off something and get you to make the cards for those and send those out where they pay an extra fee, or everybody else pays a lower fee.
That may be something we could look at, but we are trying to get the industry to go to this, but there, like you said, there may be a transition period that we could do that. I don't know. I'd have to talk with Paul about that. That's an idea.
I like everything I've heard, though. I probably personally would just print it myself and laminate it, and that'd be the end of it.
I don't see anything that like I say, the photographs are significant, but I don't see anything with what you're proposing here, the change, that would be a real showstopper as far as I'd be concerned.
And I think, well, let me see, I may misunderstood, Paul, but whenever you send me your renewal, for instance, or your application, and you have uploaded your photos, I'm going to send it back to you with the photo already on it.
Yeah.
So you won't need to do the put the photo on it.
Right.
You won't really need to even
Right.
laminate if you don't want to.
Because the photograph is part of the records that are maintained
Yes.
here. Sure, that's the way it should be.
And, you've gone to the electronic fingerprint submission. I don't know why you couldn't, I don't know why you couldn't
But would-
implement the
would-
electronic photo submission too, and then you could still do it for the smaller companies that might not have the great
Madam
technology.
Chair, we're getting
but-
there.
Thank you.
We're getting there.
Enough said.
It would be good if the photograph could be included with the information that comes after going through the QR code.
I made a note of it, so.
They would probably need a way to crop it or something so that they're picking just the face out of the, because people are going to upload
Got the got the family dog in it.
I would think for the staff's position, it would be nice if somehow the person uploading it's cropping it or doing something to it.
Yeah, well, you could tell them, like we have now, so it's a passport style. Just tell them it's got to fit in this box. Crop it to fit.
I'm just thinking about if there was an online tool where they upload the photo and then they can select it with a box and submit or something.
Do we stipulate a passport style photograph?
Yes.
Good. Well, that should clear that up.
Even that is too big. All that simply means is it is a frontal photo. It's not the side. It's this right here. This is all we want. So when you get a passport, it is a 1x1, and that is too large for us to put on the license. So we still have to cut it down with a pair of scissors. So this is all we want, says right
When
here.
you're doing that electronically, though, you can print it any size you want. That'd be a huge advantage to you, sure.
We get big ones, we make them small.
Thank you very much.
You did an excellent job.
Nice to speak with you today.
I knew I was not going to get out. Third grade.
Third grade.
I'll have to tell y'all that story. Paul's already had their presentation with my PI board, and I'm probably going to say this incorrectly. And I don't know how it came about, but somebody said, one of the members said, well, what was it about sending third grader can do that? Oh, we need to get a third grader to come in and show it to us. So I just turned to Paul and said, well, there he is. And I apologize. I did not hear what the gentleman had said at first when I pointed to Mr. Hartberger. I did apologize.
Well, you got.
I didn't even know you make it to the sixth grader level, so I was hurt.
Thank you. Okay, are we ready for your section, or do you want to do the appearances
I think
of the people that are here
actually, I
first?
think Mr. James Beatty is here. He is the gentleman, if you would go down to Exhibit E, he is with Lowe's Home Center. I asked this gentleman to come in and speak with you today. I could not decide what could be, whether he needed to be licensed or not. Sometimes it gets so technical, I'm not able to do that. So I did ask the gentleman to come in and speak to you today about what his concerns are and what he wants to do in the future with Lowe's Home Center. And I was afraid, this is the actual Lowe's that everybody knows is Lowe's. This could open up a door for other companies as well, so I wanted to make sure you knew exactly what he was talking about.
You want me to explain, or you want them to read the email?
You have, if you go to Exhibit E, if you want to kind of look that over first. I don't even have it. Did send in an email. Sign in. You need to sign. You did this morning? Did you sign? All right.
Go ahead, sir, make your presentation.
Basically, I was requesting a license because it fits that we would do this. I've had the product since 2012, and but it's a do-it-yourself, and you monitor it on your iPhone or your Android.
Make sure this red is on, or else you're not
Also,
getting
I'll
recorded.
hold that button if you want to.
Okay. And now, we're offering a premium monitoring service, which is offered by UCC. And UCC is licensed in, I'll just hold it down. And, but since we've chosen to brand it with Iris Monitoring, Iris Premium Monitoring, it's now our product. So therefore, I think we should have to license in the state of Tennessee for that purpose. The licensing piece or the monitoring piece of it is handled by UCC. It's kind of like but since we're branding it, it's ours. So that's when I applied, and then the question had come up, well, should you license, should you not? The Do-It-Your-Home kit has all these pieces that you can purchase, including cameras, but that's not monitored, it's not installed. We don't offer a premium installation. It's just the product you buy off the shelf, install yourself. And at some point, if you want it monitored professionally, then you go online and you sign up for it through UCC.
Put the charge on your Lowe's card for the monitoring?
I believe so. Well,
I think you're correct that it would need licensing from the standpoint of monitoring. If Lowe's will be billing the customer, but the do-it-yourself installation is, in my opinion, is fine. That I guess the question comes into then what employees need to be licensed, or is anyone doing any consulting? Anyone at the stores? Do they have information, or is it all going to be done online after they buy the do-it-yourself equipment at the store?
Any professional services like monitoring are going to be done. All that'll be enrolled online. There's a whole process for that. As far as the employees that would have to be licensed, because of course you don't want to license every employee in the store. It's a SKU number to them. But the Iris team that would be involved with the monitoring aspect of it, in fact, that's my job. And
are there employees that would handle if someone wants to change their call list, or they want to change their zone descriptions and that sort of stuff? Is that your people? Are they doing that all online, or?
Actually, our developers wrote into the API for Stages, which is the automation that UCC is using, and so you're just basically changing it through the UCC portal.
So you have employees, though, that'll have access to that information somewhere, somehow. I mean, if a customer, if they want to somehow or another speak to a live person, they can't they?
We have access to their billing information.
But
Because
what
I
if-
thought the same thing. Excuse me.
What about employees that are subcontracted and they work for Lowe's? Let's say I buy so many squares of siding, then I can't put siding on, but I know Lowe's has got workers that you can subcontract and they'll come and put it in. How many of those people are going to be doing this?
None. At this point, there is no professional installation. This is a subject, and actually that's how I got involved, is I was working for UCC at the time that Lowe's. I warned them exactly about that. If you offer a professional installation, then now you're going to open up a can of worms that you're going to have to meet certain requirements. So there are some states where they may do that don't have licensing requirements that would apply to them, where they'll have a referral program where they will refer a licensed contractor to do that. Tennessee's not one of them.
I think clearly the idea of selling a box of parts that the homeowner would install does not require any licensing. I mean, that's real clear. The monitoring is being done by a company that's licensed in Tennessee, UCC, as you indicated it. That's appropriate. If you have a small technical team that was involved in customer support, and I don't know whether you do or not, don't have anything like that?
Not for the monitoring aspect of it. There's a support team for the devices. You know, like you can call for, you know, hey, this box is beeping, what do I do? There's support like that. But that
You need to be licensed.
that's
What
no-
if the
that-
call-in says, I can't get the monitoring to work? What do they do then?
Well, that would, if it has something to do with monitoring, it'd have to be UCC. The device themselves, like the support line for the devices, which has been in place all this time, since 2012, and been sold in Tennessee, just like the ones that you bought at Radio Shack or anywhere else. The reason that I don't think that has a licensing requirement is because, well, it is no longer than calling Bosch support or ADI or Demco support or anything like that. You know, if you call them, they're not licensed in Tennessee. But if they're having a problem connecting to, or the monitoring's not working, I imagine their first call would be to, hey, it's not working, then it would be passed on.
The reason I ask is I have knowledge of a former employee that worked for a contractor, and he, for I'm going to say 10, 12 years, and they didn't get along. He wanted to take over the company and so forth. He goes to work for Lowe's. He's providing technical support for this system that you're selling. If they call in and say, hey, this isn't working, why? Well, you should have put it in the corner so he should be licensed. He's not. He was only a registered employee. But he's got a badge because he didn't turn it in, and it doesn't have an expiration date on it. So he's running around with a badge at Lowe's, and Lowe's has investment in him because they really don't understand that he's not an alarm contractor. They think because he's got that badge and his picture and no expiration date, that he's good to go.
I had no knowledge of this. Our support team is in Kansas.
I mean, if I know that it's happening, other people know that it's happening, and they know to call him. So everybody that purchases that system in that town, they say, oh, you need to call this Lowe's over here. They got somebody in there that's licensed by the state. He knows what he's doing. He'll come out and work on it for you. So after hours, he goes out and works on it and gets money.
Does he charge?
Of course he does. Why would he go after hours?
Is he charged as an individual or through Lowe's?
Charges the individual that purchased the.
That sounds like that's it's separate.
He's operating
But
without
it's
a
something
license.
that could happen all the time. I mean, if
Well, I mean, he's
that's
not-
why I was talking about siding. The people that put siding on. I didn't want to go here, but now I'm here.
Yeah.
You have people that do that, and you're going to have people that do this.
Well, you know, I fought the whole DIY thing from day, because I've been in the industry for 30 years. So, professionals install alarm systems. That's, why we have boards, and that's why we do what we do. But times have changed. You put it on a smartphone, it's not being monitored, it's not, and it's, you install it yourself. We can't legislate that too much. Now, anytime a police officer or fireman's dispatched, yeah, we can legislate that. So I understand your concern. And, if you share me and if you'd share a name, I could do something about it since it's the company I work for. But we're going to break rules. We just have to catch them. Yeah. So I don't disagree with that at all. And like I said, my purpose is to come down here and just make sure that we fit that piece and because, I agree that I think that we should be licensed. I think we should be licensed because we're selling a monitoring product, even though we're selling it online and all that.
I'm sorry,
Go ahead.
I don't mean to cut you off. To that point, I think his initial question is what classification should his company receive or apply for when they submit an application to the alarm board? And then there's a second component that I'm not sure if the board has considered. If this system, Mr. Beatty, if I can ask you, is offered at all Lowe's locations? They can purchase this anywhere?
Yeah, this system has been on the market since 2012.
And with the addition of the monitoring option, once that happens, I guess my question to the board at that point is, once this company is licensed under whichever classification the board decides, there has to be a qualifying agent. Does that need to be for every Lowe's location wherein this system is sold, or would that be for Iris Home Management solely? And I think that's something else the board needs to consider as well.
Well, ours is, the way it works for us is we have a different building and we're selling stuff, we have a different QA. So each individual building storefront has to be licensed and has to have a QA. So that would mean many. I mean, and once you open this floodgate, it's hard to get the cattle back in once they get out.
But doesn't all the monitoring go to one central location that Lowe's is putting their hands in the process to collect the billing?
Basically, since the decision was made to do the billing, they inserted themselves, and I say they because I was sitting on the UCC side, because if they would have just left it with UCC, then it's not an issue. But once they put their name on it, they want to bill it because they're billing now. Once they did that, it put them in that situation. Now, and here's the way I look at it, is since you don't register at the store, you do it online, it's no different than Amazon or anything else. It's one entity. So you guys make the decision, but I'm just saying that's my thought is it's one entity, it's one monitoring center.
Okay.
Many locations you can buy it at.
Do all of the locations in Tennessee
They all need QAs.
for your monitoring service, does it all go to one address in Tennessee? Or does it go to individual Lowe's stores in Tennessee?
And where would that address be, out of
Well,
curiosity?
address is actually North Carolina.
Okay,
Mooresville, North Carolina.
All right,
They're selling it in every store.
here's the way I would visualize. You're selling a product over the counter, you're exempt. That's clear, from day one. You're selling a product, it happens to be a motion detector, it's no different from selling a hammer as far as our board's concerned. If you're not providing consulting services, if you're not going out and doing some sort of installation, you're just selling a product over the counter, you're exempt. And that would apply to all of the Lowe's stores.
Do the salespeople in the individual stores where these do-it-yourself systems are sold, do they sell the monitoring inside the stores?
No, there was a discussion at one point of doing a kiosk at the stores, but that's not happening.
Will there be any in-store, like a display?
There's paperwork in the box for the premium monitoring option. And the premium monitor option, by the way, which also is so different, it's on demand. It's not even a contract. Or is like a 1-year contract or a 6-month contract or anything. It's on demand.
So when they check out of the store, when they go through the checkout line and they buy this system, they don't purchase monitoring on their way out the door?
They can't purchase it. They have to go home, go
It's
online.
done after the fact, outside the confines of Lowe's.
Why don't you walk us through the whole process? You
Go to
walk into the Lowe's store
you
and
go
what
to the store,
happens?
you pick what you need, how many door contacts, how many motion detectors, whatever you want, a camera on it, whatever. You go home, you install the system, and you register it online. It's basically IP, and you are now monitoring it on your phone. So that's the basic system. So it goes off when you're at work, you get it up, you see the kids came home and tripped the alarm. Everything's great. Now you go on vacation, you decide that you want to, you don't know anybody in the neighborhood or something like that. You don't have anybody to check on your house if the alarm goes off. Where's that box at? You pull it out, and there's a little card in there. You want to sign up for the premium monitoring. You go online, you enroll, you go through all the whole thing, and that is basically UCC managing that site. And once that's done, there'll be a testing thing that has to happen to make sure signals are going through. And once you do that, you'll get a notification that your signals are being received. And you actually see them through their portal. Because like I said, what our team did is they wrote through the API of stages so that basically you're just looking at UCC's portal. And you're seeing basically what a dealer would see.
I mean, I think you're on the right track. I commend you for coming forward and you know, thinking that you need to be licensed. I just think that we're a little different somewhere. I think there's probably some more people in Lowe's somewhere, because UCC's got a problem with a customer. This customer's irate, or they're whatever. There's some issue. They've got to have somebody, even if it's just maybe you handle all of it, but they've got to have someone that they call and say, look, I can't go anywhere with this customer. You need to handle it.
Well,
there's got to be someone.
That's part of my job is that to make sure that the monitoring is what our anticipation is, and make sure that work with the initially it was to work with the developers on the API and so forth. So any issues that we have there, I have to make sure that UCC is addressing them. And I don't see that as our problem when it's the monitoring. It's our problem as far as it's our customer. But I've got to have the monitoring company respond to why.
There's got to be the buck stops here somewhere.
Yeah.
I mean,
Yeah, but are you talking about problems with the monitoring, or are you talking about problems getting the system up and running? Either or.
both? Say the customer can't get the system. Typically, the central station isn't going to do. Now,
Well,
he
if
may
they-
have something worked out to where they're going to do tech service for him.
If they can't get the system running, we do have a support phone line.
Whose employee is that?
Do what?
Who pays their paycheck?
Lowe's
That person needs to be licensed.
Exactly.
yeah.
They need to be a registered employee.
support for the DIY product.
Yes.
Because that's who they're going to call when they can't get it connected monitoring wise. I mean, unless all they're going to say is
They're
"I
not
can't
calling
help."
Iris, they're calling Lowe's.
Right, they're calling, well, Iris is Lowe's.
Right.
It's a DBA.
I know, but you're still calling Lowe's.
Yeah, okay, well, you're calling Lowe's because you're having problems with an installation. But see, the way I look at it is, or the way I've always seen this is, it's the same thing with a Demco. A Demco is not licensed in Tennessee, and Bosch isn't licensed in Tennessee, and ITI.
They don't have access to the central station information.
Yeah, but separate things. You said if they had a problem with their installation, who would they call?
Oh, the customer doesn't call a Demco and Shields and the supplier. The customer calls the alarm contractor, which is us, and then we call our supplier.
Right.
We would be calling Lowe's,
Well,
not the customer.
Again, this is new. We're talking about something that's not really, otherwise I wouldn't be here. It's new, so,
Licensing.
okay.
And I
but-
think even the in-store stuff, I
Why
mean,
is
could
that?
be, I think where Ken, I guess was going, I don't know, I'm speaking for Ken, but that some of the in-store could be borderline. If it's absolutely selling equipment, you're not selling monitoring, you're not promoting it, there's not a sign that says monitoring available. If it's all strictly you buy this box, you take it home, and then, oh, I can get it monitored, and then call the number from there, and the store has nothing to do with it. You ask a person in the store about, how does monitoring work? And they say, oh, I don't know. You have to handle it online. That'd be okay. But if they say, oh, well, you do X, Y, Z, and all this other stuff, they're selling it. They're selling that service. They're telling them about. I mean, that's what selling is
Right.
Every
So-
alarm contractor that has a business, let's say I have a business in 3 towns, for each town, even though I'm Lowe's or I'm ABC Alarm Company, I have to have a QA for that storefront that's advertising, hey, we got monitoring, we got alarm equipment. I would have to have 3 licensed individuals in those storefronts that people were able to walk into and buy equipment.
Okay, so as long as no one at the store, or there's no advertising at the store out front, advertising monitor.
You can have a
premium
support
monitoring.
line or anything like that. You just got to be able to just sell them equipment and they're on their own. Then if they have trouble, they got to call an alarm contractor.
And have an 800 number in the box that says if you have a problem.
They got to be licensed.
I'm not sure I agree with that. I'm not sure I agree with that. They're selling the product over the counter. They're selling a box of parts. They're not doing any installation. They're not telling the customer how many motion detectors, how many glass breaks or smoke detectors or whatever.
Until it comes to the monitoring.
Yeah, but and I guess I'm looking at it from different aspects of different parts. In terms of selling the product, they're not doing anything other than what Radio Shack and others have done. Or for that matter, you can buy the parts over the internet. And so I see no requirement for licensing. I see no, in terms of sales, I see no requirement for the Lowe's store there in McMinnville to have a qualified agent or registered employees or any of that. You're just selling the product over the counter, and I would see as clearly exempt within our statute. Now, the monitoring's a little different situation. The fact that you've got a licensed monitoring company providing the monitoring services, they're licensed, they have registered employees, then that's good, and that's exactly the way it should be. Now, as to you and the group of people that are identified as IRIS and providing the monitoring and you're providing the branding for that, that's kind of a gray area in my opinion. The fact that you've come forward and will go through the licensing process, have a qualifying agent and registered employees, I think that would eliminate any doubt in my mind. I think it's probably a fairly limited number of employees, maybe a handful, I don't know. That I think would eliminate any question in my mind that you're doing what would be required at a minimum. I think you're doing the right thing, but and it would be in the monitoring category. It's a bit of a gray area.
It is, and that's why I came, because it is gray. This is new. There's nothing in the legislation specifically for this, so we're either going to have to work within it or, down the road.
And you're trying to work
something
within it, and I think it's the thing to do. And I think if you do that, you're doing the right thing.
Yeah.
And what would be your recommendation for them, though, from the standpoint of selling monitoring in the store? I mean, they're going to want to have something when they sell the box.
If the box sells monitoring available, fine. If the box says on the inside monitoring available, so what? If it says it on the outside, I don't care. If they've got a sign up next to it, monitoring available, it's still the customer's buying the parts, the customer's doing the installation, the customer's actually hooking up the monitoring online.
And if it doesn't work, who do they call?
If it doesn't work, then they probably take it back to the store and say this doesn't work.
If you take your hammer back and say something wrong with this hammer, they help you. They give you another one, or they don't make you buy another one. They got somebody there to help you.
Yeah, Lowe's. I personally hold Lowe's in high regard. My dealings with them have been excellent, and we buy a fair amount of stuff from Lowe's. Now, that's aside from the issue at hand. But no, I think that if you're licensing as in the monitoring category, your branding, location where you're doing your billing and all that, I think that would be adequate in my opinion.
And one thing, and I get your point, but the thing is since 2012, they've been selling this box and calling it a support line, and they haven't had a licensing requirement until the monitoring came into play. And that's to me, it's I look at it like you guys, because I'm an industry person, and this is what I'm doing now. So I'm supporting my company and trying to help them to fit in within. So when they want to do this, when Tennessee was a target state, I did the same thing in Florida. I said, well, hold on, there's things you're going to have to do in Tennessee, and this is. They hired a big consulting firm, the one that's advertising all the. They came up with their version, but their version was you can do it, and then no.
How does the billing work? Is it billed to your Lowe's card?
Right now, when you bill, you can do it, and putting a credit card online is the way to do it. So you can use your Lowe's card, you can use a Visa, MasterCard, American Express, whatever.
I'm sorry, I was telling.
I'll repeat what she was saying. So
I said, so we can sell parts to people. There's a lot of people that come and say, I don't need you to pull my wire. I got somebody to do the pulling the wire. And we can mount the devices, blah, blah. I said, no, you can't do that. We got to do it. So I asked him, so we can just sell parts to people and let them put it in themselves and not have to have a license?
And you could, if you were just in the business selling parts. You could have a store that was, the alarm store. And
yeah, I'd love to, but somebody's going to come back and say, this doesn't work.
And you hand them a new one, and they
tell you come fix it.
Well, they tell you come fix it, and you say, I'm sorry, we don't have installation people.
What does Florida do, sir? I mean, do you license in Florida?
Licensed in Florida as an alarm contractor.
You are?
It's
Lowe's
yes,
is?
Yes. Alarm
So
contractor's
what are you,
license.
what is the board saying? Just Lowe's gets one license, one
It
QA?
wouldn't be Lowe's, it would be.
I think we
Or
have a
Iris,
differing
whatever
And
it's
opinion.
registered
called.
employees in the monitoring category, and I think that would be sufficient. It would
Yeah,
certainly satisfy what I would feel like would be appropriate.
In the way I approached this was anyone that would have access to that portal within UCC that isn't a Lowe's employee would have to be licensed under that category.
That, to me, would meet the requirements, and that also, I.
monitoring.
In the monitoring category, and I think that would preclude somebody later on complaining, hey, Lowe's is providing monitoring services because of the Lowe's branding. And then you've got a license, there wouldn't be any question. I think it would be sufficient. Now, do we need to put that in the form of a motion of some sort, that some
That
sort of official?
Excuse me, that registered employee, where's the license gonna go?
License would go to wherever his
To the-
location
to
is.
the
Yeah.
Carolina
Could be in North
office?
Carolina.
That's
Yeah.
where the employee's gonna be doing the monitoring?
Yeah,
In North Carolina?
That's where the billing will be coming from. so I
No,
would say-
where is the person setting that's doing the monitoring?
That's
Subcon-
UCC.
And they're a licensed contractor already.
But that's why I said the billing. I figured the billing would be, because powers to be have insisted on branding that. So
Let's put this in the form of a motion to kind of wrap it up, if y'all are in agreement.
I think we need to be pretty clear about the standpoint of at the location, that there doesn't need to be any consulting or sales at the site of the monitoring.
Yes, why don't we make a motion to the effect that, based on the information presented, Lowe's is only selling the product over the counter at their stores, providing no direct monitoring services from the stores or consulting or installation from the stores. Therefore, the stores would not require licensing in any of the alarm categories. Secondly, that the company is providing monitoring services through a subcontractor, and that location where the monitoring is being handled in terms of a billing process, which based on what you've told us is in North Carolina, we would have that entity licensed as an alarm contractor in the monitoring category. And they would need a qualifying agent, and the employees there would be registered employees. So that would, if we accept that in the form of a motion, maybe that'll settle this issue.
Do you have something else?
So the bill, I'm still hanging up. The billing doesn't go to like Lowe's in Concord, North Carolina. It would go to UCC in North Carolina, but Lowe's is,
no, the billing, basically UCC,
Revenue.
it's just like a dealer arrangement for an alarm contractor and a contract monitoring company, because that's what UCC
Third party.
is. Yeah, third.
but I'm paying my alarm system contractor.
You're paying Lowe's. If you go buy one today, which the premium monitoring's not offered in Tennessee right now, but if you went and bought one today, the basic package is like $9.95 a month. Now that's not monitoring that. You're just basically paying for the app and the connectivity to your home. Because you can, it's got the automation features too, where you can adjust your temperature and turn lights on and all that sort of stuff, just like the old X10 was. But, and that's the way it's been for years. It's just they're adding this one element. So the bill currently, if you pay that bill today, it goes to Mooresville, North Carolina. And the only thing different with the premium monitoring is it would just be you'd also be paying for the premium monitoring. That's same as it was, it's just that's the element.
See, the third-party monitoring company invoices Lowe's for all of the customers in bulk.
Exactly. Every time they enlist one, they just add it to their bill. And since it's on demand, it's not full-time, because at full time, it's better just go to, well, in my opinion, it's better just go to an alarm contractor. The on-demand thing, that's the marketing thing that they went for here, the on-demand, you only pay for it when you need it or you want it.
Got a clear picture of that now?
Yeah, yeah. Hey,
He's not getting the money. Lowe's is.
Right.
I know, but I think about, I pay my licensed alarm contractor who I know he has limited, you know, he has access to my billing information. My catch in this is when you pay Lowe's for this, who's got access to the customer's billing information for the monitoring? Does that make sense?
The Lowe's, and I think
And they have.
would be the Lowe's Center there in North Carolina.
Right, just as they have now. It'll be.
And you're going to register those people, correct?
They'll register the people doing the billing.
That's, yeah,
Everyone.
that's got access to customer information.
Customer information.
Am I out of the
Is it-
line on this?
Is it,
Well, when we have billing for this, one of the key things is protection of the customer. And if you've got somebody that's got access to people's billing information for alarm services, we don't pay John Q out here. It stays inside the system where we either pay our alarm system contractor or you pay directly to the monitoring company because you've got confidential information that's being passed along.
and we do now. So, because, you know, because that's the part, that's the logic that I'm not following, is we have that that customer information now, but we're not required to.
But you're going into monitoring, which makes it license required.
Okay, so that's the reason that you're saying that.
Yeah.
Okay, so if we limited
Monitoring
billing.
If I pay $10 to use an app, okay, but when you start entering into monitoring, which is a licensed field, there's certain requirements that people involved in that process have to follow, which means.
I understand.
But
I understand.
you know, if UCC was a licensed monitoring company and the customers were paying UCC directly, where everybody's registered in the monitoring post and all that, that's one thing. But you know, you're circumventing and going through Lowe's, which gives them access to customers' confidential information. Am I correct, Ashley? Yes. Thank
Okay,
you.
Okay, so if we throw the monitoring license in there, it wouldn't require that. Understanding, though, that that's still a small amount of people.
Yes.
You need
It
to
doesn't matter if it's
register
one.
them.
Exactly, that's what I'm saying. That's fine. I mean,
But
it's
those
doable.
people
I guess what
that-
I'm saying is it's doable. Because
if you-
it's
That's why I
pretty much
didn't
automated.
understand if it was a large amount of people or not. I figured it wasn't a large amount of
It's
people.
not now because it's new. It will be.
No, it's still, once you.
Just get a larger computer.
Yeah, exactly.
Yeah, it sounds like a lot of the concept is it's going
Yeah.
to be self-service. There won't be a lot of
Yeah.
employees on Lowe's end
No.
of it.
It's pretty automated, pretty much automated.
There's another device out now. I don't know whether Lowe's sells it or not, but I mean, I have a rental. It tells me when it is lit up. It tells me when the temperature goes up and down, when somebody opens the door, when somebody comes in. I can push a button even on my phone and talk to them.
Nest.
Did that once. I said, it's not your day to be working. You know, they're just looking around. But they're going to get larger. You can put 4 of those devices on an app now. But when they go into monitoring, then they're going to have to step into this same.
I
role that you're
recommend
in.
that, like I said, everyone's going to try to fit in somewhere. It's either that or just, like I said, let's, put some legislation out there that actually covers it. So that it's outlined so that you guys don't have to decide.
I think you're correct. You need to go as an alarm systems contractor for Lowe's in Tennessee, and anybody that's involved in the monitoring process needs to be licensed and registered, correct?
Will be their QA if they have to have a license as a company.
Well, I'd say are you not qualified to be a QA?
Who's going to be their QA?
Does that sound like a doable process, Mr. Beatty?
Yes, because like
Does
I
that
said,
seem unduly burdensome?
as long as we don't have to do each store or I have to get everybody at corporate, because that's where corporate is. Yeah, I think we can do it, because I think they can limit it.
I think if we
Well,
go that route.
you've already got it in Florida, correct? And I think
Yes.
from the way you described it is very similar to what we're asking or telling you you need to be in Tennessee, correct?
Right. The test is just a lot tougher. That doesn't mean,
Missy?
that don't mean don't make it task.
Actually, it's people he has to deal with that's the problem. He was just too polite to say that.
That's just fine.
Do we need to restate the motion, or?
Let's see, based on
we've-
information, Lowe's only selling over-the-counter equipment at stores, no monitoring, consulting, or installation at individual stores. Yeah, you probably do, to make sure we cover on the monitoring part.
I was afraid of that. All right, you got the first part. As long as they're not they're selling a product over the counter in the stores. They're not providing installation. They're not providing consulting. They're just selling a product. And therefore, there would be no licensing required for those activities in the Lowe's stores. The monitoring aspect of this is being done by a licensed third-party monitoring center, so we have no issue with that. They, Lowe's, with their branding at wherever they're located, whether it's North Carolina, wherever, would be a licensed in the monitoring category as an alarm contractor in the state of Tennessee. They would have to have qualified agents, and the key people with that were involved with the monitoring and billing process would be registered employees.
Okay, did you get all of that on the record? Do we have a second to Ken's motion?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Thank you,
Okay,
sir.
Yes, let me ask a question. So Lowe's was going to register at Lowe's Home Center doing business as our small home management,
Smart home management.
smart home management?
Yes.
That would be their
The
DBA.
DBA.
Yeah, for the state of Tennessee. Thank you, sir. Do we have any more appearances here?
Yes, we do. Is Mr. Barnes here? Okay. How about Mr. Fisher? You want to come up, sir? And want to take just maybe a real small, short break for the court reporter whose fingers are coming off? Yeah, you can handle that just for a few minutes. View his experience.
Afternoon, Board. Thank you for allowing me to speak. I have an application in front of you for qualifying agent, and in that application, I listed my RCDD as the certification.
Make sure you're speaking directly into that.
Okay, better. I've listed my RCDD as the industry-approved certification. That's a BICSI certification. Requires several years of experience, to be exact 10, several recommendations from customers and previous employers to get it. The course of study for the exam includes the NEC, information from RL Laboratories, TIA, EIA, IEEE, and which part?
Mr. Fisher,
EIA.
she's a court reporter.
Right, I know.
So when you say RCDD, will you please not use acronyms so that she can figure out what you're talking about?
Okay.
And speak slowly.
Okay. Registered Communications Distribution Designer. That's issued by BICSI, which is Building Industry Consulting Services International. To receive that, the study materials are the TDMMs, which is Telecommunications Distribution Methods Manuals, the NEC, which is the National Electrical Code, as well as codes and standards from RL Laboratories, TIA-EIA, which is Telecom Industries Alliances and Electronics Industries Alliances, and IEEE, which is Institute of Electrical and Electronics Engineering. So in order to receive that certificate, I had to study those materials as well as have 10 years of experience. The qualifying agent applications that I have in front of you are for CCTV and burglar alarm. Specifically, my experience is the design and installation of surveillance systems and access control systems. So not burglar alarms per se, but access controls wherein you have a card swipe to open a door or a gate. All of these systems now have gone to IP standards, meaning they all run over traditional data cabling for the most part. It's all low voltage, and that RCDD certificate allows me to design and approve low voltage installations as per code. So I'm asking the board to allow me to use that as my approved certification.
Sir, did you bring that with you? I don't have that in your packet. I don't think that's in your information they have.
Yes, ma'am, I do. Yes, ma'am. And I did also pass the board tests that
We
were.
have a copy of your exam scores, but we
Okay.
never got your training certificate. And
Most of my experience in the state of Tennessee was with 2 fully certified electrical contractors, so I was not required to be registered.
except for the 18-net service.
And with AT-Net Services, I was registered with the company that AT-Net Services purchased, which was SDI Networks.
I didn't find any record you've ever.
In 2008. I honestly don't remember.
I don't think they ever submitted it. I looked yesterday through.
Wouldn't necessarily surprise me. I did fill out all the paperwork. I filled out the forms for the background check. I did the fingerprints, and I submitted it all to our human resources. So it should have been filed, but that it wasn't is not surprising. Did you do find that SDI was a registered?
SDI was
Okay.
until they got bought out.
Right.
I don't necessarily hold it against you that they didn't turn the paperwork in, but, I mean, some of, I'm speaking for myself, but what all did you do at you've been at, the experience is what, at Stanley, and is it A1 or AT?
Staley and AtNet
Staley,
is who
okay.
I listed, and I had there's one other company that was further back that I didn't list any experience from.
Just briefly tell us, I guess, what you did there at both of those places. Is that what you were already describing, both the places doing data and camera system design, access control?
Yes, sir. With SDI Networks, I was Regional Director of Infrastructure and Security. My scope of work included designing, speccing and designing the systems, and that was systems.
What systems?
Anything from voice data to surveillance to access controls, audiovisual systems. I also had sales responsibilities, so I had a customer load and a quota that I had to meet, but then I worked in the design aspect for the other salespeople in the company, and then I would oversee the project and project manage it to completion. And then while at Staley, I was a project manager at Staley. Most of the projects I did for Staley were out of state. They're a national contractor. They're licensed in 48 states. I would design and oversee the projects. Most of those were voice data, but there were several customers where I installed surveillance cameras and access controls.
But throughout all your experience, you have none with burglar alarms.
Not burglar alarms per se, but access controls, which is, according to my understanding, I have to have, or AtNet has to have the burglar alarm certification in order to sell access controls. We don't sell burglar alarms.
Locksmith license and sell access control.
Pardon me?
You could have a locksmith license and sell access control also.
I saw that and I questioned that. I think y'all might want to change that. Well, it's not really a locksmith. It's an electronic access control. So it's a card swipe and a magnet that releases, or
Locked door.
A locked door, yeah.
But I didn't think that locksmith covered a multi-door access control system.
Is it on my license, access control?
I think we're getting
Safe
off topic
automotive.
here.
Yes.
I agree.
Cody or Beth, can you help me identify the items that we're supposed to be specifically reviewing here?
He's here to review his experience.
And we hadn't received his training until today. Training in burglar alarm and closed circuit television, which we
I'm not familiar with the Bixie training. Can you explain to me what that is?
Sure. Bixie is an organization that maintains the codes and standards for the communications infrastructure industry. So Bixie is an acronym. It stands for Building Industry Consulting Services International. In order to receive the RCDD, you have to certify that you have 10 years experience in the industry. You have to have written letters from a previous employer, a customer, and then a third that's just a general written letter of recommendation. Mine was from a distributing partner. You study three-ring binders that are about yay thick I studied for 6 months. You also study the National Electrical Code and then codes and standards from the other regulating bodies, the TIA, EIA, and IEEE. And then you sit for an exam. It's about a 4-hour exam. There's 150 questions or so. If you pass, you pass. If you fail, they let you know you failed and what your score was. So I passed. They told me I passed.
I'm familiar with it. It is fairly extensive, and it's fairly common for the data industry. But I think it would, I mean, it definitely is a very comprehensive training and certification on data wiring and IP protocols.
Not burglar alarms.
Well, the way that, I mean, everything that he's installing, it's all so much of it is IP. I mean, camera systems, the access control. I personally would think it would apply, in his case. Of course, he's got a license then that says he can also install a burglar alarm. That's some of the, he doesn't really want that, but that's what he has to get to do access control. My guess would be that he probably has better knowledge than some alarm installers on IP stuff. I would think it would be.
You would feel like then that it is equivalent to a national training course. Basically, that's what you're telling me, is it not?
Yes.
Okay. I again, since I wasn't personally familiar with it, that's fine. I just needed to kind of understand that.
In addition to the initial training and taking of the exam, we have to maintain continuing education on it as well. I have to get 45 continuing education hours every 3 years, mandated that we attend a conference. So they make us keep up with changes in the industry.
I'm well familiar with credentials. I'm just not familiar with that particular one.
That's fine.
So if we are willing to accept that as the training, then the question comes down to the experience. And the certificates, I'm trying to sort through this. The certificates we have would indicate you're applying what for the in the burglar alarm category, burglar alarm, closed circuit TV, those
Yes,
two
sir.
categories.
Yes, sir.
Help me identify what your installation work has been in those categories. Then,
Yes, sir.
I know you touched on it, but I was reading at the same time. And
I assume from what y'all are looking at that you have my QA application in front of you. So it's addendum A is my experience. It's part 2. I listed work while I was at Staley Incorporated. While there, I designed and installed a security surveillance system and an access control system at Tennessee Packaging, which was they make corrugated boxes. They're in Loudon, Tennessee. It was 7 doors and 25, 30 cameras. Kirkland's Home Stores was a customer of mine. They're headquartered in Jackson, Tennessee. I did work for them all over the country. I did about 80 new stores. So when they would build a new store, they would put 6 cameras in the store. And I didn't design that system, but I did oversee the installation of all of those jobs. While at SDI / AtNet, and these were all actually contracted and awarded to us when we were SDI. I designed and installed a surveillance system for the Hawkins County schools, 7 schools and a little over 300 cameras total. That was a fully integrated IP system with servers at each site, new cabling infrastructure, new cameras installed. Lenoir City Utilities Board, as a customer, we designed and installed surveillance system and access controls for them. 49 cameras and a dozen or so doors and a couple of gates. So drive-up gate access where you flash a card and the gate will open. Letcher County Health Department, that's in Kentucky, but I designed and installed surveillance system and access control system for them. Knox County Health Department, that's Knox County, Kentucky, same thing. Access control system and surveillance. Both of those were small. 8 cameras at one, 10 cameras at another, and 4 doors at each of them. So smaller installations. And then Johnson University, which used to be Johnson Bible College, we designed and installed, actually we designed and installed and then uninstalled an access control system. We were the first company in the Southeast to install Cisco's new access control system. And we were the first company in the Southeast to uninstall Cisco's new access control system because it didn't work. So. That's what I have listed. That's 5 of each of them, as was required per the rule book.
Other questions? Madam Chairman, I make a motion we grant grant Mr. Fisher's license as a qualified agent in the burglar alarm closed circuit television categories.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to grant Mr. Fisher's QA license request in the categories of CCTV and burglar alarm installation. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries. Congratulations.
Thanks. Yes,
Yes, yes, it is here. I tried to put it up here where it would be out of the way. Yes. She needs a copy of it.
Do we have another appearance here?
Yes, we do. We have Mr. Warford. Charles.
H.
By Brian, if that makes any difference. And I have some more information for the board. Got 7 copies. How many would you like?
Yes, we need 5, and there's 6, and then we need 1. We need 7.
I may need one of those to reference myself.
Okay,
Thank you.
Ms. Warford is Exhibit H.
A lot of stuff to look over. We'll just take a minute to go through everything.
Take your time.
So what are we looking at? Is our main concern experience, qualified experience?
Yes, I believe that's why he's here.
Correct. I've been working in the low voltage field with home audio type products since 1990. And I was at Nicholson's Hi-Fi, not far from here, for 16 years, where I did design, sales, and installation of all kinds of low voltage systems.
What all kind of systems did you?
At Nicholson's, well, we did distributed audio and video, so whole house music, TVs in multiple locations. We did very large homes with complex lighting control systems with computerized, panels to control the lights throughout the house. We did touch screens where you could control the lights and the temperature and the music and tie all of that together. So we did the highest levels of home automation that are available. And I've continued to do that since I established my company in 2007.
This license application is for security?
Security and CCTV.
Okay. Do you have any sort of experience in the closed-circuit TV installations?
Yes, the large home that I list on this security, it's the first set of pictures. You can see that's the gate control, which I did not do, but there's 2 cameras built into the gate control, one of which you can see hanging down below it. There are 6 other cameras on that property that are, they're not internet cameras. They have a local DVR. We started doing video doorbells back as early as the mid-90s at Nicholson's. So I've been doing CCTV for a long time. Not a whole lot of it, but for a long time. But more and more, because of the internet-based cameras like the gentleman was talking about before, more and more people are asking for it because it's not cost prohibitive like it used to be.
I would feel like the AV experience would come under the CCTV, would be comparable there. You have the issue of kind of the catch-22 where we've got unlicensed activity being the experience required. I don't doubt that that you can do the CCTV, and obviously you've done some alarm work.
Right.
I think we're just kind of in a sticky situation as far as
Sure, I understand that. And, if I need to pay a fine or something for that unlicensed activity, I'll just say as a personal word, it was really interesting to me that I was able to go to local distributors and sign up to buy the equipment, that I was able to hook up with a central station company, that I was able to get an alarm.com account, and nobody said, do you have a license in your
You just
state?
have an honest face.
Yeah, that's right. So I regret that I didn't have a license, and that's what I'm trying to make right. And once I did realize that, I stopped marketing it, until such time as I could get right with the.
Well, the fact that your experience was unlicensed experience doesn't negate the fact that it was experience. I personally, after looking at the documents presented here, would feel like that Mr. Warford's experience would be adequate to meet the licensing requirements. Like I say, the fact that some of it was not licensed experience doesn't negate the fact that it was experience. The closed circuit TV experience is a little thin, but as Scott mentioned, I think it would probably be adequate. So I would make a motion that we accept Mr. Warford's experience as meeting the requirements. Now that would there are other requirements that still have to be met in order for his license to be issued.
But I need to take the courses and so on.
But in terms of the experience, I would feel like that I could accept what he has presented as appropriate documentation. So I make a motion that we consider Mr. Warford's experience as presented for the security alarm and closed circuit television categories as adequate.
We have a motion by Mr. Roberts. Do we have a second? No second.
Well, I would like to second it, I guess, for discussion. I'm inclined to agree. I mean, I feel like the experience is adequate. I guess I would like to discuss it if you have, if we've got other thoughts on the board.
This would not be directly granting his license. This would just be accepting his experience.
But if he passes.
Yeah, he's.
Yeah, I have a copy of it here, and a copy should be in your packet. I passed the LEC online, one of the ones that was acceptable to the state of Tennessee. And, you know, my next step after coming today, were you guys to grant my experience as adequate, would be to take the state recognized CCTV and security courses, and of course to pass those before I would do any other activity.
You still have a quorum unless it's challenged.
See if she's going to come back.
We've got a motion and a second. I mean,
Okay.
we could go ahead and vote on it.
I was just going to give her.
Not feeling well, she didn't have a problem with this, did she?
It was, well, I'm not gonna say it.
I guess so.
Let's go ahead and vote on Mr. Warford. It is Warford.
Warford, yes.
Experience. Just experience only. He would still have to
Meet other requirements.
meet all the other requirements from training and as well as testing in order to qualify for the qualifying agent in CCTV and Berg. All in favor, voice by saying aye.
Aye.
Motion carries. Thank you, sir, for coming.
We appreciate you coming forward and making an attempt to comply with license. There probably will be they will open a complaint or as far as the unlicensed. We can't really address that today, but take that personally. It's just
I won't. Not at all.
And you are doing the right thing.
Right.
Well, I'm trying, and whatever I need to do to comply with the
Some companies are a little more customer oriented than others.
That's correct. And I'm a one-man shop, and I'm known for my customer service, so.
All
Thank
right.
you very much.
Thank you, sir, for coming.
I will bet.
Yeah, let's do that.
We'll do that.
Let's give her time to cut the cameras off.
The UT Virginia game, OUA.
Okay, we're going to come back to order this Thursday, October the 20th, 2016 meeting of the Tennessee Alarm Systems Contractors Board. Ms. Vest, I'm going to defer to you where you want to go next.
All right, thank you. Now, we do have two other appearances that did not appear, obviously. Did you want to look at their paper application, or do you want to wait till
Barnes
they?
wasn't supposed to be here.
Who?
Barnes, the QA, and Van.
We can go ahead and finish up with these if you like before we go into mine. So I think what we're going to take is Exhibit F.
And this is for his QA review.
This is to review his degree. He's trying to qualify with an associate's degree.
His is in mechanical engineering.
Excuse me.
looking at just the education and not the experience? Because I don't see.
His experience, he's got over at least 4 years, which
I would make a motion that we accept Mr. Barnes's mechanical engineering technology degree.
Okay, we have a motion by Mr. Cockcroft. Do we have a second?
Second.
And a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, the next one we're going to go to is H. No, I'm sorry, is I. Anthony Van Horn. This is,
he got everything expunged, but he can't prove it.
this you're reviewing the criminal record on Mr. Van Horn.
Off. I can just smell like burning coffee, and I know.
That's my coffee. I've set it on fire. I like it
Old
where
and
you,
burnt.
I like it where you can tap dance on it.
In this case, he has the experience and training. It's just his criminal record we're looking at. What category is he?
Oregon CCTV.
Y'all had a chance to review it? You want to make a motion on it?
I make a motion to approve, what's this, file 1961, approve the,
Excuse me, we have a motion by Mr. Cockcroft. Do we have a second?
A second.
And a second by Ms. Jones to approve file number 1961. All in favor, voice was saying aye.
Aye.
All opposed? The motion carries.
Okay, good. Thank you. Now we'll go to Exhibit I.
What about B, C, and D?
That was Exhibit I.
I think it's labeled different in different places. Okay, let's say I saw F on the file number.
So we have,
Well, I think now we're at my position, my point in the.
so you want to go and go to
presentation.
yours instead of the employer? Okay.
We're going to go to Exhibit B. Disciplinary action report. All right, this form, I don't know if I presented it to you the last time like this. It is somewhat different from the old form that we used. Disciplinary action for August, you did not have any. September, you did not have any activity, but you can look at the form and see the other programs do. We can go to Exhibit C. Of course, if you have any questions, please ask me. Exhibit C is your monthly report for the month of August and through September. This is I turn in every month to the Assistant Commissioner's office. Tells what we have been doing in the office. Your program still has Karen Jones and Mackenzie Roberts. These board members continue to serve until a reappointed or another appointment's been made, because both retired 12/31/15. On September the 21st through September the 23rd, Beth, Bell, and I went to the Association. We had a booth and we did a presentation.
An excellent presentation, I would add.
Thank you. We appreciate that. It was a good turnout. We really enjoyed it. And out of that did come something else. We are going to, for security personnel, security guards and trainers and companies, have a seminar November the 9th. It's to help individuals know how to navigate our new computer system, the online applications, the renewals, the electronic fingerprinting, the changes we want to make in the applications. All that's going to be done in the seminar in different parts of the state. What came out of this one, but we went up there for that, was that I was asked perhaps we can do that for some of the alarm and companies' actual employees that work on the applications or hire the individuals. You might have a compliance person that does that. So Beth and I will be working on having another seminar just based on the alarm industry, probably after next year. After this year, excuse me. Next year is 2017.
But I already have people call me wanting to know when it's done.
No, we have not set that up yet. We're doing one at a time. So we're really excited about that they're really interested enough to listen to us talk again. And actually, like Paul Hartberger had said earlier, if you go out on the website, you can click on the little video that they did. It's very, very helpful. Okay, so if you don't have any questions about that, we'll just move on to Exhibit D at my budget review. Excuse me. This is a new form and new way that we're doing this as well. You're going to be given this sheet that says alarm surplus / deficit. Fiscal year ending July, begins in July 2016 and ends in June 2017. And each month they're going to be able now to break down your revenue versus your expenses.
I got this one up on the screen if it'd be easier for y'all to see that way.
All right. So we really don't want to get too alarmed on what we see, because this is for the whole year. So each month is going to be somewhat of a variance there. Because right now it's showing that you are in a deficit of $7,617. No, $7,617. That was dollars. Okay. But the month before you had $21,862. So as the month goes, you have a well, now I'm not really concerned about that. This program's already had enough that monies that they do are self-sufficient. But you can see it breaks down your expenses that have never been able to do that before, where we go for the Edison expenses is our computer. Administrative cost backs, that's for our office and the assistant commissioner, the commissioner, whomever else that includes. Now we have how much your attorney sitting next to me cost. Legal cost backs.
Wow. Why is there such a great difference between July and August? Is that cumulative or is that independent?
But that's supposed to be an actual what is charged per each month. If you have investigations that you have to have for these complaints, this is what we were talking about earlier this morning about that 70. It'll be a terrible expense on this program if we kept that up. You have your investigation cost. Field enforcement, I don't believe we ever have any of that. In the customer service center is a new telephone system, the Zendesk. We have one person that is designated in our office 7.5 hours to answer the telephone for all our programs. We have several people that answer the phone in customer service as well. I do not have any legislative update to bring to you. That was next on the agenda there, but there has not been any. So if you don't have any questions, I believe we'll just go down to the alarm employee application review if you'd like. And I believe we could start with Jay. I want to review his criminal record, this gentleman's criminal record. I didn't get my... Excuse me. This gentleman was convicted of disorderly conduct on 10/23 of 16. February the 23rd of 07, it was criminal attempt, theft of property. Aggravated robbery was reduced down to a lesser offense of attempted aggravated burglary. Amended to simple assault. And it's a 9-year-old charge. He does tell you on his application a couple of these.
Oh, wait, because I think you said 2016.
What did I say? Okay, I'm going to make a correction to this. The first thing I said, it should have been 10/23/05 instead of 16. Since it's only a 9 years old, I wasn't able to approve it in the office. It does have the written explanations included. Then you do have, there's actually just a master output. It's a printout from the computer about his charges and his convictions.
Madam Chairman, I make a motion that we do not grant this application as registered employee.
We have a motion by Mr. Roberts to deny this registered employee application. Do we have a second?
I second.
And a second by Ms. Jones. All in favor, voice.
The extensive criminal history.
So it'll be under the poor moral character clause.
Yeah.
Poor moral character.
Okay. We have a motion by Mr. Roberts, a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The application's denied.
All right, thank you. Now we'll go to K. This individual here, November the 18th of 2000, had a DUI, was guilty, got 12 months probation. 8/8 of 2009, a DUI, guilty, 12 months probation. 5/20 of 2014, a DUI, amended to non-fingerprintable charge. 6/25/16, a DUI. He did not provide any written explanations.
What is the applicant?
Okay. Madam Chairman, I make a motion we grant this application.
We have a motion by Mr. Roberts. Do we have a second? Okay, the motion fails for lack of a second. Do we have another motion? Motion, folks. It failed.
It died, okay, for this lack of a second. Okay, I'm
Correct.
sorry, I
We
didn't
need a
hear.
motion.
I feel like it would be in order to ask the person to come appear before the board. Very recent, this this charge.
Are you putting that in the form of a motion?
Where does the gentleman live? Do we know? Okay.
Say most of his arrests have been in North Georgia and Middle Georgia. Okay, are you going to make that into the form of a motion to have him to appear?
Yes, I'll make a motion to ask Alks to come appear before the board at the next meeting.
With his DQA.
Yes.
Okay, we have a motion by Mr. Cockcroft to require Exhibit K and his DQA to appear before the board. Do we have a second? I'll second it. All in favor, voice by saying aye.
Aye.
Aye. All opposed? You got a vote?
Didn't vote.
Moving right along. Did the motion carry? All right, moving right along to the next one. It's gonna be L. Okay, on 9/23/1996, vehicular theft, guilty, 3 years probation. 7/17/1999, he was held for a Colorado charge for a bad check, and they classified it as a felony. On 3/20/2007, unlawful carrying of a weapon, got community service, and he was discharged.
I'll make a motion to approve file 35394.
Okay, we have a motion by Mr. Cockcroft to approve Exhibit L. Do we have a second?
Second.
And a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Right, thank you. Now we'll move down to the last one, which will be M. We do have a written explanation on this one. 193/2003, forgery, guilty. Receiving stolen property was nullied and bad checks. There were 7 checks that you got for forgery, got pretrial diversion, and it is over 10 years old.
Madam Chairman, I make a motion that we grant this application.
We have a motion by Mr. Roberts to grant Exhibit M, registered employee application. Do we have a second? I'll second it. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, thank you. Now I believe we can move on down to the alarm employee application review. No, oh, we just finished that. Oh, I'm sorry, I'm just all over the place here. I guess we're down to the education. Excuse me. Which would be Miss Bell.
I know I sent everything to Keith, Ken, and Scott. Did anybody review? I know.
I looked through all of them. The concerns are the ones that are proctored qualifying course, for burglar alarm qualification, fire alarm qualification. They had been approved prior. This is for renewal.
Beth, your mic's not kicking up. Sorry.
Probably because I'm not speaking into it. They have been approved. I believe they were initially approved I want to think it's been at least 8 or 9 years ago, I think.
All the continuing ed looked fine to me. That's my only concern. I think that we've got to make a decision as a board. Do we want proctored exams or not? Or do we want... We accepted something with a video proctor.
We haven't. I think I've seen one certificate for that course. And it wasn't for a qualifying agent, it was for employee training. Most of the certificates we get in are for either the NTS courses. And I have a new proctor that's an online. You have to be at your computer. It randomly comes to see who's sitting at the computer taking the class. I think they've just moved to that in the last month. And then the elite CEU qualifying education courses, they actually have to go to PSI and take a test to complete it. These are the only qualification courses I'm aware of that we have on our list right now that are not proctored.
Let's take these one at a time if we could. I went through all of these courses very carefully and have some issues with some of them.
Well, I really think what Grant did was go back to exactly what he had sent us the last time they got renewed, which would have been...
Some of these were just junk.
Yeah.
Let's look at them one at a time if you don't mind. First of all, the CenturyNet course for 2 hours of continuing education titled Beyond the Signal. I thought that was fine and would recommend that it be approved. 2 hours continuing education. Looking at the LERC courses, they vary tremendously. Let me see if I can put these in some sort of order. The Tennessee Fire Alarm qualification course, they are requesting, they submitted them two different ways. They submitted them as a group. The course that's listed as Tennessee Fire Alarm qualification course apparently it comprises 3 separate sections.
Part 1, 2, and 3.
Yeah, part 1, 2, and 3. Now they are apparently asking that the combination of the 3 be suitable for initial application, although they didn't check that on the application. Let me take a look at the courses themselves. Give me just a minute here to get this organized. All right. The Tennessee Fire Alarms course, part 1, they made an application for it to be continuing education, 8 hours. Now, there was just not enough material presented with the application to assess whether or not it would be suitable for 8 hours of continuing education. The second page there, they listed, there are all sorts of errors in this thing. For example, and I'm looking at the second page, dated 1 October 16, they make reference to the NFPA 70 2015. There wasn't an NFPA 70 2015. It was one in 2014. So, just the application in itself has an error built into it. But there was not sufficient information to judge whether that would be good for 8 hours continuing education or not. So I could not recommend that be I could not recommend that it be approved because I don't have enough information to judge.
And I would agree that they're not 8 hours for any of those.
Well, again, there wasn't enough material presented to judge, even if it's just continuing education.
So does that apply to 1, 2, and 3?
Yes.
They're all requesting 8 hours. I don't think
They're
any of them-
requesting 8 hours of continuing education, and there's just not enough material submitted to be able to judge. And so I could not recommend that they be approved based on the information presented. Well, let me move to those, if you would. Let me look at the Tennessee Fiber Optics, Tennessee Fiber Optics Basics Part 1. That would be, they're requesting 4 hours of continuing education, and I feel like that would be appropriate. So I would recommend it be approved for that. On the other hand, the material submitted for the Tennessee Fiber Optics Basics Part 2, where they're requesting 8 hours of continuing education, the material submitted with that was identical to Part 1.
Well, now the list that we have on the iPad says 8 hours for each of those. The
Well,
basics.
The application that I have and printed off says 4 hours continuing education for Basics Part 1, and that would be reasonable.
So basics part 1 for 4 hours.
Yeah, the Basics Part 2, the material was identical to Part 1, word for word. So I could not recommend that be approved because the material submitted just doesn't match what they're asking for. Okay. If I may move on, the Tennessee Data Telco Standards. They're asking for 8 hours of continuing education. I do not see that course could possibly be worth 8 hours of continuing education. 4 hours, perhaps. So I would recommend that it could be approved for 4 hours, not 8. And I don't know whether you looked at that or not, Scott. Did you have an opinion on that one?
I looked at all of them. I mean, I really thought, I didn't notice that I was going to that Part 1 and Part 2 were the same. I was going back to look and see if what I had was the same on both of them. I don't think that any of them are 8 hours worth of training. I was okay with all the classes, the courses themselves. I do think they're applicable to the industry and to the work being done. Talk to you on that.
Let me move on. The Limited Energy Calculations Basics, they're requesting 8 hours of continuing education. I cannot see that material presented would be worth 8 hours of continuing education, 4 hours at best, and I consider the course very marginal. So I would recommend that be approved for no more than 4 hours of continuing education. The Tennessee Access Control Basics course. They are requesting continuing education, okay. They are requesting 8 hours of continuing education. I can accept that. However, on page 4 and page 8, the spelling of summary should be corrected. They misspelled it in both places.
So you're okay for their recommendation on the access control for
8 hours of continuing education,
okay.
Yes. Now, the remaining course that I have, I think there's one remaining course, is the Tennessee Berg Qualification Course. That is one where they are, they are applying. It's a bit confusing. They are applying for 24 hours, and I assume initial application. They are wanting to renew the course. They misspelled the word summary on page 7. I can accept that as an initial qualification course, although I think we need to get back to the discussion as to whether or not the course should be proctored to ensure that the person taking the course is actually the one that is taking the examination.
All right, so the recommendation on some of these is to only approve for 4 hours.
Yes, that's correct.
Okay, now on the firearms.
And continuing education.
This is just continuing education right now.
Right.
On the fire alarms, part 1, 2, and 3, I've got my notes that you don't think there's enough material.
No, there was not enough
There's
material
a
there to judge the
error.
quality of the course at all.
So we're just not even gonna review that, because
No.
they didn't send enough material.
That's correct.
Okay, that's rejected. On the access control basics, there's not 8 hours of material. Do you have a recommendation on the number of hours we could approve that
Oh,
for?
he said he approved it for
I'll
8
take
hours.
it for 8. Limited energy calculations, the recommendation is we approve it for 4 hours of continuing ed.
4 hours continuing education, yes, that's correct.
Data telecommunications, the recommendation is to approve for 4 hours only.
Right, 4 hours
Data
of
slash
continuing education.
telecommunications. All right, and then on the fiber optic basics, part 1,
Would be approved for
4
4 hours.
hours of continuing ed only.
That's correct.
And fiber optic basics, part 2,
It would be rejected.
completely.
Yeah, the material's the same as part 1.
Okay.
But I looked at on that, I mean, there was a different outline in the beginning. It's covering, there's only so much you can cover in fiber optic splicing and everything else, but
Do you think, I mean, again, if you could either reject it and he can resubmit it?
I was thoroughly unimpressed with the quality of his presentations.
Okay, so we're at the very bottom, now we're ready for the qualification courses. Do we wanna hold on those till he resubmits the other stuff? If they're a combination of these courses and you won't approve them for continuing ed, I can't even consider them for qualifying education.
Right.
And the issue of them not being proctored.
Well, y'all haven't made a ruling on that. I've warned him that this could happen, but, I mean, it's,
Also, did you get the beyond the signal at the top for 2 hours?
Ken recommended that's okay for 2 hours.
Yes.
Okay, so we're not even gonna consider the qualification courses until everything gets resubmitted?
Correct.
And are we gonna make a decision about being proctored or not?
Do we want to take that as one consideration, or do we want to break that out?
That's two different things, other than I hate to reject it because it's not enough material and then turn around at the next meeting and tell him we've decided not to accept it because it's not proctored.
Good point. What do the rest of you think?
I agree. I hate to approve it and then come back and tell him no because it's not proctored.
I think they should be proctored. I think there should be some form. We probably were stretching the bounds with video proctor.
Well, are we talking about the continuing education being
No.
proctored?
No.
You're just talking about the initial application being proctored. All right, I agree with that. So we could approve then the courses that were submitted for continuing education,
Had the items that we could review.
items we could review, but because they were okay, maybe at best. Like I said, I was thoroughly unimpressed with the quality of the materials he
Is it an
presented.
online course?
Yeah.
So we aren't entirely seeing it as it's presented, I guess, but.
I
he
don't
has-
think, and I'll be just totally honest with you, I don't think they've been updated here and there. He also used to offer the Charlie Pierce CCTV lake training, and he had to quit offering that because it hadn't been updated in so long. So
If I understand correctly, his courses are really only accepted by 2 states, ours and I forgot whether it's Washington or Oregon or someplace out west. Yeah, his home state and our state are the only ones that appear to me to be accepting his materials. Except, as far as I can tell, his home state and Tennessee are the only places his materials are being presented or being approved for use. And he in his advertising, makes a big deal that Tennessee has approved his courses for various purposes. I said I was thoroughly unimpressed with the quality of his materials and presentation.
Right, do we need a motion that we're not gonna accept qualifying education courses unless they're proctored from hence now forward, or?
Well, first of all, I make a motion we accept the courses that I've outlined for continuing education. And I don't want to go through that list again, but I think we've got
Have you
to
got,
identify it.
Jenny, did you get that? Okay. Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to accept the list with the modifications that have been read into the record. All in favor voice by saying aye.
Aye.
All opposed? So that part's taken care of. Now we're moving to the issue of the initial application.
I think we are undermining the entire process of requiring education for our qualifying agents if we do not require that the courses be proctored in some fashion. Now that would be my opinion, and I don't want to try and get into detailing how they should be proctored, but in this case there's no indication that they're proctored in any way, and I feel like that is insufficient to meet the appropriate statutory requirements. So I would make the motion that we do not approve courses for initial application unless they are proctored in some fashion. As far as I know, that really would only apply here. Am I reasonably correct in that, Beth? Yeah. Now, not anything against this particular course provider, but I just do not feel like it's adequate to meet what the statutory expectations are.
I agree, and I think that it does follow the statutory requirements because the course that's cited in the statute and as an equivalent or an equivalent was an in-person proctored test. I mean, it was a course and test all done in person. So I don't think there's some concerns that we aren't within the statute to make that. Okay, because I think it definitely requiring proctored follows the statute of what it was in.
Right, and as the board, you can, set your own standards as far as education and training is concerned, and that's part of it. So there are no rules, you've not set any rules to restrict it, so you can change your mind as needed, as the industry develops, or as you see fit.
Did make a motion, right?
Yes.
Ken did.
Second.
Okay. We have a motion.
Down.
Huh?
I've got it written down.
Yeah, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to not approve any courses for initial application or, what did you say, for qualifying
education.
agent unless said exam is proctored. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Includes the education report. Thank you.
Okay.
It was a pill going through all those darn courses.
I can imagine. Do we
Could I
have
say-
any unfinished business?
Just the new business, I think.
New business.
Under the new business, we have already passed out, I believe you have the 2017,
The 2017 what now?
dates for the board
Yeah.
meeting. If you have any problems with that, you need to let us know as quickly as possible.
I also saw as part of an attachment that you sent on the parking, there was a new per diem and other rate that's taken place.
Yeah, October 1st every year, they update the per diem rates, and I sent y'all copies of that just so you know how much you get reimbursed on the hotel. I think Nashville, for board members, is up to 171 now. It's 161 for just regular staff. The mileage and the food per diem rates, I think they may have gone down a little bit. The mileage hadn't changed, but I sent that out just so you guys would know What?
It's if you didn't see it, it's at the bottom of the parking pass email. Okay.
I can send it again.
I saw it.
No, I scrolled on down to see if there was anything else, and I saw them there.
I just wanted to let y'all know the hotel rates had gone up slightly effective October 1st.
I'm glad, because it's getting almost impossible to find a
Hopefully your
motel.
ID card will help some, and it's not gonna get any better. Even when they open the new hotels here in downtown Nashville, the rates are not gonna go down.
Well, it doesn't matter, because I book online, and when you try to put a state government rate in there, it'll say, no government rates. I mean, they don't even give you a choice for the.
You have to call the
rate.
hotel property directly to get a government rate at all anymore.
Sorry, stand corrected. We do need to vote on the new dates for 2017.
Vote on our meeting dates? Have these been checked against major conferences and events?
Events that were
Actually,
happening.
they kind of follow the very same schedule you had this year, which I had already researched the holidays and the NCAA tournament and everything else, but you never know. There are so many conventions here in town
Yeah.
now.
I know March was always a bad time because of the NCAA
I don't think y'all are
tournament.
meeting in March.
No, we've skipped March this year, and
Yeah.
we're skipping it next year too. So.
Yeah. That's the PI commission has to deal with that. Now they're stuck with the St. Patrick's
Well, we have to
Day.
deal with the fanfare, so it's all 6 of one,
Yeah.
half a dozen of the other.
Madam Chairman, I make a motion that we adopt the meeting schedule as it's presented to us.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to adopt the 2017 board meeting schedule as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Okay, any more new business?
That's all I had, thank you.
What about the fee schedule? That was, did we need
Yeah.
to go over this, or?
I need, actually, yes, we don't need to go over it at this time. We will hopefully go over it the next time. I've been asked to present that to you for you to take another look at that. There are some high penalties there. There are some high penalties.
And if the board members can just be looking at that and be thinking of ways to maybe reduce that, or which of those violations, other than the two we discussed this morning, that could be handled administratively, rather than bringing them to the board further and vote on at the next meeting in December.
Are some of these ones that we need to change because of the statute, where, like the first one on this list?
Right.
Says-
The first one on the list is the unlicensed activity,
And
and
it's-
by statute, it's a minimum of 1,000 up to 5,000. So,
Because ours has got 500, so we need to change that to 1,000. Are any of the others statutory, Ashley?
they're not.
So we going up on the rates?
Well, that one we may have to, but some of the others we probably should go down on. That one, we don't have any choice, it sounds like. If it doesn't go to a formal hearing, do we not have the ability to offer a lesser if they'll take a civil penalty? I mean, how was it being done before? Just wasn't so proper?
Probably not.
People
But-
weren't complaining because it was less than what it was supposed to be?
Right, but the statute does say if there is a finding that there is unlicensed activity. So if they're agreeing that there is a violation of that statute, the civil penalty is 1,000 minimum. And I guess we're just gonna go with what the statute says from here on out. And that, like I said, that's just for unlicensed activity. That's the one that is set forth in the statute. Everything else is what the board has decided.
That's the only one that has a
Set amount.
set amount, okay. All right, well, thank you for providing that.
Anything else?
I can email that to you also if you want to make some typed in recommendations. If you want to do it that way, I'll just email it to you.
Good, thank you.
That'd be good, then you can send them back and we can compile it for when we come back.
All minds clear? This meeting is adjourned until December.
Thank you.
December